Good morning, everyone. We are glad to have everyone gathered here today. And we are going to start with our first case of the morning, case number 23-3061, Hunter versus Elanco Animal Health. And is it Mr. Cry?
Correct, Your Honor, thank you.
All right, Mr. Cry.
Your Honors, may it please the Court. The District Court rejected the complaint in this case because plaintiffs had not alleged that Elanco had engaged in a channel stuffing scheme that was itself fraudulent and illegal. That holding disregards the basic allegations of the complaint, the theory on which it rested, and the structure of Rule 10b-5. This case involves allegations of false and misleading statements about the reasons for Elanco's revenue growth. It does not involve allegations that Elanco engaged in channel stuffing that was itself illegal or fraudulent. Rule 10b-5b independently prohibits companies from making false or misleading statements about the conduct they engage in that would be material to investors, whether or not that underlying conduct is also independently a fraudulent scheme or practice under Rule 10b-5a. And that's the fundamental flaw that undergirds the District Court's entire opinion. The Second Circuit, in the Heinz Celestial case, reversed a District Court for committing that exact same error. In that case, just like here, the District Court had rejected claims of channel stuffing because there was no allegation that the channel stuffing itself was fraudulent or illegal. But here, just like in Heinz Celestial, the Second Circuit explained that whether or not a complaint states a claim for false or misleading statements about channel stuffing does not depend on the legality of the underlying conduct. What matters is whether Elanco made materially false or misleading statements about the reasons for its revenue growth. And that's exactly what Elanco did in this case.
So, Mr. Cry, can I ask you, the various statements that were made by Elanco and its officers reference what they call the underlying demand.
Yes.
Okay. What is your understanding of what that term means, underlying demand?
So in context, Your Honor, I think the fairest interpretation of that term is underlying demand means the underlying consumer demand, the underlying end user demand that is driving the ultimate demand for Elanco's products. And
as opposed to the demands of the direct customers, the distributors.
Correct, Your Honor, because if they were just referring to distributor demand, it's hard to see why they would use the underlying word. Underlying what? I mean, that's their immediate demand to the distributors they're directly selling to. So even if there's ambiguity on that point, I think definitely the fair reading and the one investors would most likely draw is that those are references to end user demand. And that's not just coming from that word alone. It's also coming from the very words that Elanco used when they referred to underlying demand. Because
were there other statements that Elanco made, by Elanco I mean Elanco writ large,
sure.
That instead of using the term underlying demand, they just used the term demand when they were referencing their direct customers?
You know, I think that when they were referencing their direct customers, they almost always use the term underlying demand. So the examples we collect in paragraph 131 of the complaint, there's a reference from the CEO who talks about the underlying demand coming out of the clinics, or the strong underlying demand at the clinic level. That's from paragraph 140. And then there are situations where they do use underlying demand without, in the same breath, saying demand. So for example, paragraph 124 talks about the demand pull-through in vet clinics, and then a little bit later talks about underlying demand. So we think in that context, especially where Elanco is just repeatedly using the term underlying demand to refer to clinic or end-user channel demand, what investors are going to understand from those comments is that they're talking about how much the ultimate end users of their products want them, how much they're able to move out to the ultimate consumers of the product, not how much inventory they've managed to pile up at their distributors through exorbitant rebates and other channel stuffing schemes.
What evidence do you have, though, that if we come at that same question from a different angle, that the demand was not real?
So yeah, no, this is not a fictitious revenue case. We're not alleging that they
I'm
violated.
pretty much going more so to the scienter question. I'm trying to move a little bit into the scienter
Sure.
question.
So we think that there's ample allegations in the complaint that the two principals of Elanco that made these statements, Mr. Simmons and Mr. Young, knew that when they said that Elanco's revenue growth was being driven by end user demand, that was not true, and they knew it was being driven by the mounting inventories that were piling up. And I think there's basically 6 categories of evidence we would rely on for purposes of that scienter. And the first 3 are categories of direct evidence. So in paragraph 78 of the complaint, we have Elanco's former head of global animal care expansion attended monthly management meetings throughout 2019 where reports were presented directly to Mr. Simmons and by Mr. Young that showed a consistent delta between the selling numbers and the dispensing numbers. So that is an allegation that they had in front of them, reports that showed that there was this consistent gap between how much was going to distributors and how much was going to end users. Not only that, but this individual...
But I guess to follow up on Judge Pryor's question, why does that indicate some sort of nefarious intent?
Well, that alone...
I mean, because there'll always be a gap, won't there, between presumably the distributors, want some inventory, and they're forecasting kind of what their customer demand will be, and as part of that, their inventory will fluctuate over time, and so it seems like it's economically prudent for Elanco to make sure it understands what the inventory is so that it can plan for the future. So I'm trying to understand why that's kind of nefarious.
Right, so that is not what paragraph 78 alleges. It doesn't say that distributors consistently had some inventory, as a buffer. What it says is that every month there was a consistent gap between how much was going into distributors and how much was going to end users. So yes, I for sure agree it would be rational for distributors to carry some inventory, but if you have a situation where every month you're selling a certain amount to distributors that is far in excess of what then goes to end users, that is problematic. And maybe it's not independently illegal, but it does put those principals on notice that when they go out to the market and say our wonderful revenue figures are because of this burgeoning end user demand, they know it's not true because they saw these reports that every month showed them that there was this consistent delta. They were pushing more into the distributors than the distributors could resell. But you do not need to take my word for it, because what paragraph 78 also alleges is that they were specifically confronted, challenged over this practice during these monthly management meetings. Elanco's global head of animal care expansion was an eyewitness to those exchanges, and that individual reports that the CEO and the CFO were specifically challenged on the channel stuffing practices that were reflected in these reports. And so that is well beyond, that's a big problem for Elanco.
And Mr. Cryer, I interrupted you when you were going through the various factors
Sure.
in response to Judge Pryor's question.
Yeah, so that would be number one, and that's corroborated also by Elanco's corporate account manager, who also attended some of those meetings. The second category is that same corporate account manager also testified that there were days on hand reports and roll-up reports that both Mr. Simmons and Mr. Young reviewed on a monthly basis. And a days on hand inventory report, by its very name, that is a report that shows you how long that inventory is sitting there. And so if those reports that they're reviewing again and again and again throughout the year show this days on hand continually going up and reaching stratospheric levels, like over 120 days of inventory, just wildly beyond what's normal in the industry, that too is notice that they knew that when they told the market the reason our revenues are going up is because of end user demand, that was false and it was misleading, because the reason those revenues were going up is because they were driven by channel stuffing. Number 3 is the monitoring that Mr. Young and Mr. Simmons told the market themselves that they engaged in. Paragraph 117 of the complaint, Mr. Simmons says, "We look every day at that vet clinic demand. So these end user sales are not some line item buried in the recesses of the company's accounting systems. This is something that the CEO and the CFO of the company told the market they were looking at every day. And number four, now we get into what I would call circumstantial evidence, because there's a lot of that too. And so one example is the testimony, the report that was given by Elanco's corporate account manager, who explained that that individual's superior, Courtney Schreiber, whenever Mr. Schreiber attended a meeting with Mr.
No, this was not based on personal knowledge. This was based on, from lack of a better, just from someone else, from hearsay.
It's not hearsay, Your Honor.
That's why I'm asking.
It's not hearsay, because what that witness recounted was that every time there was a meeting, so he had personal knowledge of the fact that Mr. Schreiber was meeting with Mr. Simmons and Mr. Young. And then every time right after that, what happened is Mr. Schreiber would say, okay, go ahead and engage in all these aggressive rebate and channel stuffing practices. And so the fact that the timing of those two things happening one after the other is circumstantial evidence that tends to add to all the direct evidence we have, because it suggests that Simmons and Young were the source of the instructions that Mr. Schreiber then relayed. And clearly, if we were saying that this corporate account manager relayed what somebody else had told somebody else that would be hearsay. But this is not hearsay. This is a recurring pattern where right after these meetings that the CEO and the CFO attended, he got CW1 got these instructions to then go off and engage in channel stuffing.
But again, isn't that a little bit of a stretch to suggest that from that conversation that this confidential witness would have had personal knowledge of what's occurring at the meeting, aside from what the directive was? Because he's attempting to link what's happening in the room where he is not present with what the direction is being given. I'm just trying to, because the district court did do a weighing of that testimony.
We would not claim this is independently sufficient
Okay.
evidence of channel stuffing, but it does tend to reinforce what's going on. And in that same vein, we also have the risk factor. They added to the reports in November 2019, and this is when they decided to add to their, right at the tail end when the channel stuffing was really nearing its breaking point, they add a risk factor to their public reports that says, and I quote this, increased or decreased sales resulting in a higher or lower inventory levels that could result in customer demand being in advance of or trailing the revenue. So, a completely anodyne, uninformative risk factor, but it does use the word inventory, and that it just communicates so little that I think the only fair way to read that risk factor is they realized this was a problem and they wanted some risk factor somewhere they could later point to if somebody tried to hold them to account for that.
I'm sorry.
I guess looking at it from kind of stepping back and looking at it from like the 20,000 foot perspective. These distributors these distributors are buying from Elanco, and then they're hoping to sell it, right? And so in other cases that you cite, they had provisions that allowed the distributors to unconditionally sell back or return products that they couldn't sell, right? And the courts in those decisions found that was a significant factor in basically saying that these quote-unquote sales were just pretext, right? Here, the rate of return over the class action period is extremely low. In fact, it decreases over the class action period. And so I'm trying to understand what economic incentive would distributors have to buy products that they didn't think they could sell? And if they did think they can sell it, well, how is meeting that customer demand somehow improper?
Okay, so first of all, meeting that customer demand is not improper. The allegation is that you can't allow suppliers to pile up inventory and then mistake.
But it's the supplier's decision, right? Whether or not,
it is.
I mean, Elanco's customers, sure, in the end, Elanco wants end users to want Elanco products, but because it benefits Elanco indirectly, because it creates demand for their distributors, and in return, their distributors then want more products from Elanco. And so when the distributors buy this excess inventory from Elanco, aren't the distributors taking the risk that they may not be able to sell it? And so if that's the case, and maybe the distributors are wrong, maybe they can't sell it, maybe they're right,
So
but Elanco is looking at the kind of market as a whole and trying to assess what the demand is, presumably also based upon what their distributors are doing with, or how much the distributors are selling. And so I'm trying to figure out, economically speaking, it all seems very plausible to me what happened here. And so I'm just trying to understand kind of where you think that there's something economically untoward or unsound that can only be explained by kind of this misrepresentation.
Okay, the reason why distributors would be incentivized to purchase this product is that they were getting these whopping 20% rebates, or rebates that kicked in only after 90 or 120 days. So they wouldn't be doing this but for those rebates.
But those rebates were disclosed, right? They were part of the GAAP accounting, and
Correct.
Elanco disclosed those to the market. So the market knew that that's how these were being sold. So once again, I'm trying to see what the problem is with Elanco. You said there's no problem with Elanco selling excess inventory distributors, right? We've
Correct.
kind of taken that. And so if Elanco is using those sales as a factor in trying to gauge underlying demand, and Elanco has disclosed through its accounting practices how exactly what its relationship with the distributors are, I'm still trying to understand how it is that the market was deceived or how Elanco was deceiving the market.
The market was deceived because Elanco said the reason our revenue figures are going so high is because of end user demand, and that wasn't true. The reason was because inventories were going to stratospheric levels at distributors. So that is the problem, and the fact that Elanco may have told the market we use rebates does not then allow it to turn around and lie about the reason why inventories are going up so much. And two other important points on this. Number one, we are not making this stuff up. There was an independent analyst from Evercore who published a report shortly after the corrective disclosure in this case, and he interviewed numerous distributors in Elanco's distribution chain precisely to figure out what was going on there. And the conclusion that independent analyst drew was that this had nothing to do with the pandemic. This need to get rid of $60 million or $140 million of excess inventory was precisely because Elanco had been selling inventory at much higher rates than distributors could move out. So, independent analyst research confirms the plausibility of the complaint's allegations.
But is there any allegation, we got to back up for a minute, is there any allegation in the record that Simmons and Young, when confronted about channel surfing, how they responded?
Right, so the complaint explains how they continued to push out products until December 2014, and that's when the company reached its breaking point. And so
But
that's
how did they respond? You earlier you said there were several where they were challenged at these meetings about channel suffering. How did those Simmons and Young respond to that pressing?
They stayed the course. They continued to engage in channel stuffing practices until it reached its breaking point in December of 2019, and that's when they realized this couldn't go on anymore. They were getting too much pushback, and so they made the decision.
But is it your contention that they represented, though, or admitted the business practice of channel stuffing? I want to make sure that we're clear. Is that the allegation? Because we're saying that they were challenged. And so my question to you is more pointed and what was the response?
Sorry, if the question is how did they respond at those particular meetings? Mm-hmm. Yes, that we don't have in evidence or in the pleadings, but obviously that would be something we'd want to explore during discovery. What the relevance of those meetings is that they were on notice. They knew facts that alerted them that the representations they were making to the market about the reasons for the revenue growth were wrong. How they responded to those allegations in meetings would certainly be interesting to know, but that doesn't mean that they weren't on notice. They were still on notice. And then the last point I make, and this is also responsive to the issue you raised, Judge Lee, is about motive. Because there are reasons that Elanco did this, and that, as we've described, include the corporate transactions.
Given the amount of time that we have, I wonder if you could address causation.
Sure.
Because from what I understand, one of the distributors did experience a decrease in inventory during the class period. And then you have the COVID pandemic come, and presumably, presumably it turned the whole world upside down so far as supply and demand. And so I was wondering if you can address causation.
Yeah, so you referred to two things there. First of all, the inventory going down. There was one supplier for one product line where inventories went down between January and June of 2019. There's certainly nothing in the complaint that suggests that overall inventory levels went down, and everything in the complaint is to the contrary. With respect to the COVID-19 pandemic, the complaint has ample allegations from which a jury could find that the COVID pandemic was not, or at least not the only reason that Elanco found itself in a situation where it had to reduce these enormous inventories. And there's a few different things I'd point to. Number one is this same report from Mr. Rafat at Evercore. He looked at this specific issue for the specific purpose of deciding whether Elanco's representations, what it told the market, that the reason it suddenly had to get rid of $140 million worth of inventory was because of the COVID-19 pandemic, was true or not. That's what he looked at. And what he concluded was maybe the COVID-19 pandemic had something to do with it, but I don't think that was most of the reason. Based on the research he did, based on the distributors he talked to, he concluded and told the market that the main reason they had to get rid of all this excess inventory was that they had been selling distributors more than the distributors needed or wanted or were able to resell. And so again, don't take our word for it. That's independent research from a market analyst who analyzed this for the specific purpose of deciding whether this was COVID-19 or whether it was channel stuffing. That's
Okay.
not the only thing, because
Mr. Cry, you're beyond your rebuttal time.
Thank you.
But you can finish your answer to Judge Lee's question, and then we should see if we'll have you back.
Thank you. And so I will point to Mr. Rafat's testimony. The other thing is the complaint explains how the decision to stop the channel stuffing activity occurred in December of 2019, and that makes no sense if the COVID-19 pandemic is causing that, because that really only emerged at the very end of March of 2020. And then the third thing is that the distributors, the other firms in the same industry, did just fine during the first quarter of 2020. They really didn't get hit until later that year because the pandemic was just emerging. And so if the reason why Elanco had to get rid of $60 million of inventory in first quarter of 2020 was because of the COVID pandemic, then that's just inconsistent with the other evidence that's out there. So we would submit, Your Honor, that even if the COVID pandemic might have caused part of the loss, the complaint plausibly alleges that it certainly did not cause all of the loss. And I'll reserve the rest of our time.
Thank you, Mr. Cry. You don't have time to reserve, but we'll give you
I
some time.
appreciate it,
Mr. Silbert?
Thank you, and may it please the court. I'm Greg Silbert from Weil for Elanco. I'd like to begin with your questions, Judge Lee, about distributor relationships, and then address your questions, Judge Pryor, about Scienter.
Well, actually, I wanted to start with where we
Yes,
ended,
right.
which was loss.
Loss causation, okay.
Yeah, yeah.
Can I put that on the list, or would you like to start there?
I'm going to ask you a question about
Yes,
it right
please.
now. So Elanco decided to start working down its inventories in the fourth quarter of 2019. And so does the fact that they did that necessarily mean that Elanco had started implementing the plan and much less completed it, in the same quarter? We look at the complaint, the second amended complaint, and it says because their distributor channels had become overloaded, they decided to change their strategy in the fourth quarter of 2019 and then began working down the inventory in the first quarter of 2020. So what's implausible about that sequence of events that the plaintiffs have alleged in the complaint?
Yeah, and let me add one more allegation from the complaint to the ones that you just mentioned that I think is illuminating. That's the allegation about inventory levels at the end of 2019, fourth quarter of 2019, because there's a very interesting correlation that the complaint alleges, 2018. Very interesting correlation that the complaint alleges about channel inventory in Q4 18 and Q4 19. And what's interesting is those inventory levels are exactly the same. In both quarters, plaintiffs say the channel was completely stuffed, Q4 18 and Q4 19. then you look at what plaintiffs alleged happened in 19. I know this is leading up to an answer to your question, Judge, I promise. If you look at what plaintiffs allege happened in 2019, and they acknowledge this at page 6 to 7 of their reply brief, they allege that inventory levels went down and down substantially. This is at paragraph 66 and 72 of their complaint. So when the channel is fully stuffed, and in the midst of what they say is the channel stuffing scheme, they allege in paragraph 68 that the channel stuffing scheme was in full swing, that Elanco was heavily relying on channel stuffing all through the first half of 2019 up to the beginning of the class period. And what do they allege happened to channel inventory? Exactly what you said, Judge Lee. Channel inventory fluctuates, and according to their own allegations, the inventory went down and down substantially in the first half of 2019. So what that shows, Your Honor, and this goes to your loss causation question, is that even when channel inventory levels are what plaintiffs call completely stuffed, that inventory can and was then sold through to end users, because remember, as Judge Lee also pointed out, there is no dispute that return levels during the so-called channel stuffing scheme were extremely low, and in fact significantly lower than return levels prior to the alleged channel stuffing scheme. So we know from plaintiffs' own allegations that what they call a completely stuffed channel can then be sold through to end users. Now you said, Your Honor, well, what about what they allege was the stuffed channel at the end of 2019? Exact same thing. No reason to think, based on Elanco's past experience, that that inventory would not be sold through to end users. As Judge Lee pointed out, the distributors are spending their own capital on that money, on that inventory. They have no incentive to spend that money unless they think they can sell it through. They can't return it, as in Hine and the other cases that plaintiffs rely on. So they're buying it because they think they can sell it. Elanco's recent experience shows that they can sell it. Then plaintiffs say, well, and this is where you started, Your Honor, well, but in 2019, they say you made a decision to change strategy. Well, that decision that they're referring to in 2019, Your Honor, was a decision to consolidate distributors from 8 down to 4. And if you read the May 9th statement that Mr. Simmons makes, that is in the complaint, which plaintiffs say was when the so-called truth was revealed, what he says is, we consolidated distributors from 8 to 4. We gave those 4 distributors specific demand generation targets. And that began in 2020. And then I met with them. Mr. Simmons met with them each and every month to analyze how the distributors were doing with respect to demand generation. And he then concluded, and he points out this is different from their historical practice, that distributors were not driving demand at the same levels that they had in the past. And so that is the only kind of change in policy that's really alleged at the end of 2019, is the consolidation of distributors. None of that suggests that the channel inventory levels in Q4 2019 were somehow unsustainable or could not be sold to end users. And in fact, plaintiffs' own allegations state that when Elanco had the exact same level of inventory in Q4 2018, that level of inventory was sold through to end users. And that brings out what I think is the principal failure of this complaint, Your Honor, which is it does not have one particularized allegation about what end user demand actually was. The premise of the lawsuit is that Elanco knowingly sold more inventory into the distribution channel than end users could absorb. But not once do plaintiffs tell you how much inventory end users actually could or did absorb. Now, compare the absence of allegations in this case about demand to the allegations that were present in Tell Labs, the last case that this court had about channel stuffing. In Tell Labs, there were specific, particularized allegations about demand that rendered the defendant's statements false or misleading. The defendant's largest customer had slashed orders. There was an independent study commissioned by the defendant that cost $100,000 that concluded that demand had evaporated. There was an internal memorandum inside the defendant company that predicted that revenues would fall by hundreds of millions of dollars. There were fabricated purchase orders resulting in massive returns of products that the defendant's customers had never actually ordered and didn't want. And so, given all that, when the president of the defendant company was asked, how is demand doing for this product? And he responded, growth is continuing, or something to that effect. There was ample reason, based on the allegations in the complaint, to conclude that that statement might be misleading. Here, you have the exact opposite. You have anodyne statements about growth and demand remaining strong, or we feel good about demand in the clinic level, or we're happy with our growth. And at the same time, the plaintiff's own allegations show that while yes, the company was aggressive, as it should be, in making sales to its customers, its direct customers, the distributors, who, remember, also buy our competitors' products, right? They buy Elanco products and they buy our competitors' products. And
what do we do with the allegation here, at least in the complaint, that this information, this business strategy was not shared?
well,
because it's the omission. Because maybe we need to answer that question under subsection B. Does there need to be the channel stuffing itself? Does that need to be fraudulent?
The channel stuffing itself does not need to be fraudulent, but the plaintiffs do have to make a particularized allegation that shows why a statement is false or misleading. Now, when you mentioned disclosures, Judge Pryor, the use of distributors to drive demand was disclosed. In fact, that was disclosed as early as the IPO registration statement in 2018. Also disclosed were the use of sales incentives, like rebates or discounts, to drive sales to Elanco's direct customers, the distributors. And also, as Judge Lee mentioned, all of these sales were properly accounted for in the quarter that they were made, including accounting for any rebates or discounts. So what we have are real sales to distributors to incentivize demand at the end user level. That strategy was disclosed. The discounts that are used to incentivize those sales to distributors was disclosed. And all of these sales were properly accounted for.
Mr. Silbert, if you were going to talk about a bit more about the relationship between Elanco and its distributors. You mentioned that the distributors are not exclusive distributors. In other words, distributors buy from Elanco and they buy from other competitors. And so what benefit does Elanco gain by its distributors buying more Elanco products versus its competitor products?
The benefit to Elanco, Judge Lee, is that those distributors are then incentivized to sell Elanco products over our competitors, right? Because as you pointed out, these are real sales of Elanco products to the distributors. They can't return it. They pay for the products, and then the distributors own them. And when the distributors own them and they can't return them and didn't return them, the distributors now bear the risk of loss, right?
So if the distributors say, let's say they have 120 days, work days of inventory, right? It's Elanco's, and that's total inventory. It would be Elanco's economic interest to make sure that they have as big a portion of that 120 days access as possible compared to its competitors, because then it's the distributors would be economically incentivized to push Elanco products to end users.
That's exactly right, Judge Lee. And that distributor-led sales strategy was disclosed. And as I mentioned, the discounts that incentivized the distributors were disclosed. All those sales were real sales, not fake sales like Hein and the other cases that plaintiffs rely on. And all of the sales were properly accounted for. So
plaintiffs indeed allege that Elanco repeatedly, I'm looking for the exact language, repeatedly disclosed information about their inventory, their rebates, so forth, so on, all the things you've just discussed. But they've reminded us this morning that it's, in their view, it's just too general, too vague. What's your response?
Well, I don't
the
think
references to those particular items.
I think what my friend Mr. Cry said was too vague, and I believe this is what Your Honor was referring to, is risk disclosures about changes in channel inventory levels. I think it's, first of all, important to look at the timing of many of those disclosures. This is one of them forms the basis of Plaintiff's Securities Act claim, right? And that very same risk disclosure, which you'll find at paragraph 199 of their complaint in the securities context, is also alleged at paragraph 151 in the Exchange Act context. So they claim that that disclosure was both unlawful under the Exchange Act and the Securities Act. First of all, when you look at it, all it says is changes to our distributor levels or relationships could affect our business. That doesn't seem to be false or misleading in any way. And second, with respect to the securities registration statement in particular, and this is true of all of their Securities Act claims, remember the timing. The registration was filed in July of 2019. So this is a period where, again, by plaintiff's own allegations, you had the channel completely stuffed, according to them, in Q4 2018. And what happens in 2019? Well, they tell you themselves at page 6 to 7 of their reply brief and 17 to 18, that channel inventory level goes down by a lot during the exact same period that plaintiffs say the channel is being stopped. So there's no reason for Elanco to think or disclose at any time during that period that, hey, because we had X level of inventory at the end of 2018, that means that our sales are going to fall off a cliff, or our business is going to collapse, or anything else. What it shows, what plaintiffs' own allegations show, is that for a long time, and remember, plaintiffs allege that the channel stuffing, as they refer to it, began even before Elanco's IPO, even before it separated from Eli Lilly. So it was going on, according to them, for some 2 years. What plaintiffs' allegations show is that strategy was working. And as you pointed out, Judge Lee, the distributors are buying the inventory because they want it, and they bear the risk of loss. They would not buy it if they didn't think they could sell it, and plaintiffs' own allegations show that they did sell it. I don't want to lose your question about Scienter, Judge Pryor. Would it be okay if I went to that? So what plaintiff pointed to first with respect to Scienter is an allegation by confidential witness 4, saying that he saw a consistent delta between selling and dispensing numbers, and confidential witness 4 makes a similar statement at paragraph 83. He says inventory levels went up, up, up. Now, the first thing to point out about that, once again, is that plaintiffs' own allegations contradict it. Compare paragraph 66 and paragraph 72 of their complaint, where they talk about inventory levels in 2019, and what those paragraphs show, and again, what plaintiffs acknowledge, is that inventory levels at the very largest distributor went down. Now, I believe I heard my friend Mr. Cry say, well, that was one distributor and it doesn't mean anything. First of all, MWI was the largest distributor that Elanco had, according to the allegations in the complaint. Second of all, according to the allegations in the complaint, the food or farm animal business, which is what those allegations concern, was the majority of Elanco's business during the class period. And third, according to, again, plaintiffs' own allegations, feed additives, which were the subject of those allegations that I just referred to, were especially conducive to channel stuffing because they had such a long shelf life. So those allegations concern the core of plaintiff's case with respect to channel stuffing, and what they show is not what CW4 supposedly said, consistent delta, or if there was a delta, what it would mean is that distributors were selling more to end users than they were buying from Elanco. And again, remember, during this exact period where plaintiffs acknowledged that inventory levels were dropping, plaintiffs also allege, and this is at paragraph 68 of the complaint, that Elanco was heavily relying, their words, heavily relying on channel stuffing, and that the distribution channels were completely stuffed as of the beginning of the class period, which was May 2019, the exact period in which the levels of inventory in the channel were dropping and dropping significantly. So not only did plaintiffs not have any particularized allegations about what end user demand was that would render any statements about demand false. In addition, their own allegations contradict their theory that if the channel is stuffed, according to them, hit its peak back in Q4 2018, that inventory cannot or would not be sold through to end users.
What is your view of what underlying demand means? What did Elanco mean by that?
I think the most natural reading of that phrase, underlying demand, is demand by distributors. I think my friend asked what is it underlying? What it's underlying is the growth and performance of the company. That's the answer to that question. And when Elanco was referring to vet clinic demand, it said specifically demand at the vet clinic. In almost every case, those statements were in the nature of, we feel very good about vet clinic demand, which is puffery and immaterial, or we watch vet clinic demand every day. My friend quoted that one when he was up at the lectern. That is not alleged to be false. So we think that what the references to demand, we believe, are most naturally read to refer to demand by Elanco's direct customers.
Just to shift really quickly, as you answer that question, I want to talk about just a little bit the Securities Act, Section 11 and 12A. What, in your view, would have been the appropriate, should it have been Rule 9B or Rule 8, and explain why?
Well, so I think that at least with respect to the second statement that the plaintiffs allege under the Securities Act, which is the risk disclosure, the appropriate lens for that statement is Rule 9B, because as I mentioned, that exact same statement, I mean verbatim, word for word, is alleged to be both a Securities Act violation and also an Exchange Act violation. Obviously, the Exchange Act claim does sound in fraud, and the only difference is that that same language, once appeared in a registration statement and once appeared somewhere else, but it's the exact same words. I don't think that where the statement is made makes a difference to the market. And when you essentially, and again, there's no difference in theory about why that statement was supposedly false. Plaintiffs, essentially quote a number of sort of anodyne statements about demand or growth, and then say, false because channel stuffing. So it's essentially, and I think to compare, you could see the Securities Act claim makes the allegation at paragraph 199. It's at paragraphs 150 and 151 for the Exchange Act, but it's the exact same theory. And so that theory sounds in fraud when it's an Exchange Act claim. It sounds in fraud when it's a Securities Act claim, and so Rule 9B would apply. But to be clear, Your Honor, we don't think that the distinction between Rule 9 and Rule 8 ultimately would change the outcome here, because that's a risk disclosure. It's not false. The only other statement that the plaintiffs challenge under the Securities Act says our revenue grew 6% in 2018 compared to 2017. 3% of that was due to higher prices and 3% of that was to volume. There's no allegation that that statement is even false. And it doesn't reference demand. It's simply a report about year-over-year revenues and what portion of the revenue growth was attributable to increased prices versus increased volume. That's certainly not false or misleading.
Okay, Mr. Silver. Is that your concluding thought?
No, thank you, Your Honor. We believe that you should affirm.
Thank you. Mr. Cry, we'll give you 3 minutes.
Thank you, Your Honor. And I do just want to make a couple quick points in response. First, the fact that Elanco used rebates and sales incentives was certainly disclosed in very general, very vague terms, but nowhere did Elanco disclose that it was using rebates that were designed and had the effect of stuffing its distribution channels. It used special incentives where distributors got extra rebates if they held inventory for 120 days. It had special rebates that only kicked in during the last week of the quarter, where it had every incentive to shift sales early. And so without those additional specific disclosures, no investor would have realized that what was going on here was channel stuffing from the mere fact that Elanco said, we use rebates. Second point, Judge Lee, Your Honor asked a number of questions today about possible economic theories, why it might make sense for a company to change its strategy and fill up its distributors with 120 days of inventory. Maybe there's some competitive reason for that. And that may well be true. But the fact remains, even if it's economically rational to do that, you can't then turn around and lie to the market about why your revenues have gone up. And that's what the problem was here, is they didn't go to the market and say, the thing that's driving our end user, the thing that's driving our revenue is the fact that we've changed our inventory strategy and now all our distributors are holding twice as much. What they told the market was the reason why our revenues have gone up is because of the robust growth in our end user demand. And it doesn't matter whether they had an economically rational reason to come up to start channel stuffing or to double their inventories or do something else. You cannot lie to the market about why your revenue is growing up, and that's the core of our case.
Mr. Craig, what about, how would you address the statement by Mr. Silbert that the complaint does not have any allegations with regard to the actual end user demand, and in what way the statements were false?
So coincidentally, that was my third point, Judge Lee. And in fact, the complaint does allege that, because what it says is that when this reached its breaking point, Elanco itself told us how much the channel stuffing had been. It said we have $80 million of inventory we had to reduce in the first quarter, $60 million, and another 80 to 100 million in the second quarter. And then Mr. Rafat from Evercore looked in that and said, yeah, those reductions are not because of the COVID pandemic, they're because of channel stuffing. So there is a dollar figure put on precisely that. But when you combine those two allegations, what it showed is that Elanco stuffed its distribution channels to the tune of 140 to 160 million, and then it spent 2020 working that inventory back down. My fourth point is that the way Elanco responds to our arguments here about cases like Hein and Telabs is those cases are even worse. There they had fictitious revenues, they had an unrestricted right to return, they were sending people products they didn't even order. And that's just not a valid defense in a securities fraud suit. If you violated the statute, you can't defend yourself on the ground that there's another case where somebody else did something even worse. This case stands or falls on whether they made false and misleading statements about the reasons for Elanco's revenue growth. And they did that, and for that reason, this case should be allowed to proceed. Thank you, Your Honor.
Thank you, Mr. Fry. We thank the parties and will take the case under advisement. Our next case of the morning is case number 23-3109 and 23-3138, LJM Partners versus Barclays Capital. All right, and we'll recognize Ms. Lawrence.
Good morning. May it please the court. This court should reverse the decision of the lower court on statute of limitations grounds. This is a CEA case where the district court actually upheld the manipulative device claims on the merits, only to erroneously dismiss it based on timeliness alone. In demanding that plaintiffs name the unknown defendants by February 2020, the court set up an impossible and unworkable standard for us.
Let's talk about standing first, if you don't mind.
Your Honor, I had reserved the time. My colleague represents LJM, then standing solely relates to them.
So we're going to split up.
That's how we had to do it. I cannot speak to their standing. I
Understood.
represent Two Roads. I apologize.
No, it's fine.
So back to what I was saying. It sets up an unworkable standard on the statute of limitations. Indeed, the lower court's decision stresses that the complaint survived because it alleged such things as which defendants performed the manipulative acts and when those manipulative acts were performed. But we simply could not have known those things prior to receiving Doe discovery.
But why is that the case? Doesn't the complaint the original complaint, I mean, alleges that it alleges injury, alleges that your client was injured. It alleges that based upon the statistical analysis of kind of the market movements, that it was exceedingly improbable, I don't know if that's a term, or impossible, for that market movement to have taken place absent some manipulation. So you knew at the time that there was, or you alleged that there was some misconduct there and that you were injured by it. Why isn't that enough? Isn't that the general rule with regard to federal claims? It's basically that you know that you're injured, and you know that you were injured because something bad happened.
In this case, the lower court applied Rule 9b, and under Rule 9b, that simply wouldn't be enough. What's important to remember is that the initial complaints had only public data. The public data only gives a snippet and doesn't even give you any clue as to who posted those quotes. It's only with the non-public data that you can see the patterns of manipulation and the general picture of which defendants, whether by pseudonym or when unmasked by name, were placing quotes when. And even furthermore, it was only later in the game, once SIBO filed its declaration, that we could recreate the VIX in order to say which manipulative quotes were quite possibly or most likely included in the VIX. And the district court opinion stresses that when deciding scienter. So without those facts, we simply could not have alleged scienter. We could have tried, but under 9b, we would have failed.
The district court also takes your client to task for waiting until 2 days before the statute runs out before filing the complaint. Could you address that, please?
Of course, Your Honor. So the short answer is it wouldn't have mattered. LJM filed in January of 2019, and they're sitting here today with me. There is nothing we could have done that was different. LJM twice moved the court for expedited discovery and was twice denied. Both of those denials, despite what defendants may say, were based on overarching principles of streamlining with the MDL. They didn't have anything to do with the quality of the request, but it was the court's interest in streamlining and preventing tag-along cases. It
didn't have anything to do with kind of how broad the requests were, because certainly that was one of the defendants' argument in opposing both requests, was that they were basically going into merits discovery, and that the requests themselves were too broad for what your client wanted to obtain.
So when one reads the district court's decisions and the oral arguments on those requests, it's very clear that the reasons that the district court gave for denying those two requests for expedited discovery were because of concerns with streamlining with the MDL. In fact, in their reply brief for the second motion to expedite discovery, LJM specifically said, if this court has overbreadth concerns, we'd be more than happy to address them with a narrower subpoena.
Does it matter that then the MDL is dismissed and you still wait three weeks, I believe it is, to file?
We waited about 2.5 weeks to file at that point. That's simply the timing that it took to draft a complaint and to get it on file. I don't think that plays into the larger analysis. Whether we would have been 3 weeks before the February date or a week before, that doesn't play in. We were simply trying to file the best initial complaint we could file. But I'm glad Your Honor asked about equitable tolling, because even if this court decides that the statute of limitations should have began in February 2020, and I do believe there's an ambiguity in this circuit and in the statute of limitations for CEA claims itself, but even if we don't look at that, equitable tolling principles simply must apply in this case. This circuit has
How are you able to demonstrate the diligence, though?
Absolutely. So at every step of the way, and I know because I lived it, we tried to obtain the discovery necessary to plead our claims. So not only was it over 16 months that we were delayed because of the MDL stay, but it's over 13 months that we were delayed by SIBO's inactivity from producing a wrong data
But again,
set.
though, we're not dealing squarely with the issue as the district court posed it. When you file September 4th, 2 days before, if the accrual date is when the actual injury occurs, we're not dealing with the question of the awareness that once you filed it on February 4th, being aware that that would not toll the statute of limitations because it's filed in the names of John Does. You still don't know the names of the John Does to stop the clock. And so going back to the question, the diligence of why before the 4th of February was this not filed? With the understanding that SIBO would not have responded to a request to disclose those names, at least to two roads, and there not being a lawsuit in place.
So my answer to that is twofold, Your Honor. The first is, obviously, we very quickly, once we filed, and we being two roads, moved for that expedited discovery. The other answer I would give is, again, to show that LJM had done everything in its power, besides honestly pestering the court, to try to get the expedited discovery. So, and then the
But
other
it sounds as though we're wanting to kind of attach our wagon to LJM. Their diligence equates to our diligence as well. Is that the argument?
I certainly think LJM has a better equitable tolling argument. The rational answer for why we waited until February was, first of all, we were watching the LJM case. And second of all, this is a fund that lost $610 million and had to liquidate. And our primary concern was trying to make shareholders whole. So it was a very frantic time period when that was our primary concern. And when there's a discovery stay in place already from the MDL, it seemed like we should have put our energies there. And frankly, that's what we did. I noticed the clock and I need to reserve time.
Thank you.
Thank you.
Are we hearing from Mr. Cortazar now?
Yes.
Have I pronounced your name correctly?
Correct, yes.
Okay.
May it please the court, business partners like LJM suffer injuries when their partnerships do, and their derivative injuries establish Article 3 standing. This is the holding of this court's decisions in Adco Oil Company versus Revell and Frank versus Hadisman and Frank.
Let's look at indemnified capital investments.
Yes.
All right. In that case, what I'm listening for is not derivative, but an injury in fact to LJM. And so when we review the complaint, we do exactly what it speaks in the voice of these third-party plaintiffs. So what I'm wanting to hear is, what is the injury in fact to LJM?
So the injury in fact to LJM is that it held an interest in these partnerships and it suffered when those were liquidated.
And what are the interests that LJM had with, so not the 44 individual investment accounts. You want the court to just focus on the limited partnerships?
The limited partnerships, as well as under Rule 17, we should be able to ratify, because as we were preparing this complaint, we were in constant communication with the separate funds who were relying on us. So we really had a real party interest problem. We understood that by filing under LJM, that would be the most efficient way of bringing the complaint, and that it would simplify
And
the
what
proofs.
is the interest in the limited partnerships that LJM had?
It had a continuing interest in them being extant, and it would have had reimbursement rights for any success that those funds had.
And where is that alleged in the complaint?
That's what I'm asking.
So it's alleged in paragraph 3, where it says that LJM and its funds suffered catastrophic injuries.
You also have an appendix.
We also have an appendix
To the
that
complaint.
explains the different funds that were all listed there. And so I think that there's a strong inference from the fact that that paragraph 3 mentions LJM and its funds in the conjunctive, and in the appendix
I'm
itself.
trying to separate, I know what the complaint says. I'm asking you, counsel, to separate it from the conjunctive. I'm needing to hear an injury in fact to LJM.
Right.
Which we keep collapsing, but I'm asking you to pull it apart.
So LJM had reimbursement rights. It had ownership rights in a certain percentage of all of the limited partnerships.
And where is that in the complaint?
It is not explicit in the complaint, but that is an inference that must be drawn under Frank versus Addison and Frank and under ADCO Oil. That's the holding of those cases. In those cases, there was no, the court wasn't concerned about the specific allegation that the partnership owned, or that the general partner owned X percentage. It flowed from the very nature of partnerships and the understanding that partners themselves are not going to go through the work of joining the partnership, of going through the work without some compensation right. At this point, I'd like to reserve the remainder 2 minutes of my time.
And so before we do that, I still need to answer the question regarding the 44 investment accounts. What's your position regarding standing for, because we have to ask the jurisdictional question.
Right. So for those 44 other non-partnership accounts, LJM would have had an interest in being paid a certain percentage of the success of those accounts. And so when those were liquidated, those reimbursement rights went under. But I think it's important to understand that under Rule 17, there does not have to be...
Can I get to Rule 17
Sure.
if you don't have standing?
Absolutely. Well, number one, we would have standing under the partnerships regardless under ADCO Oil. And so then that would allow us to use Rule 17 to bring everyone else in. And that's essentially what happened in CW Capital in the dicta in that case, where the court said these were two companies
What you're alleging, though, what I'm hearing you tell me is that because I have standing for 6 companies, that spreads to 44 individual accounts that I don't have standing for.
Correct, because that's under the complaint. I think there's an understanding that LJM suffered catastrophic injury because of all the harm that was caused to the funds. And that's in paragraph 3. It's also in footnote 4. Thank you.
All right, thank you, Mr. Cortazar. Mr. Davies? Yes.
Good morning. May it please the court, Andrew Reese Davis arguing for the appellees. The judgments should be affirmed based on the allegations in the complaints. Both plaintiffs' claims are time-barred. LJM also lacks Article 3 standing because the complaint does not allege it suffered any injury. And finally, contrary to the district court's conclusion, these complaints do not plausibly plead a claim under the Commodity Exchange Act. I'd like, if it's okay with the court, to start with the time bar issue, which deals with both cases. And I'd like to start, if I could, with the equitable tolling piece of this, because a successful invocation of equitable tolling would be the only way this claim could possibly not be time barred. Based on the allegations in the complaint, these plaintiffs were aware of their injury in February of 2018. It was based on publicly available order activity, and they told the district court, this is at DSA 300, referring back to their original complaints, they wrote, the only missing information from plaintiffs' complaints is the bare identity of the Doe manipulators. And the district court accepted that argument at DSA 303 and granted them Doe discovery in 2020. My friend made a reference to Rule 9b, and I think was arguing that there should be some delayed accrual because of the need to plead under Rule 9b. That is not right. I'd refer the court to the Supreme Court's decision in Rotella against Wood, 528 U.S. at pages 560 through 561, where the Supreme Court rejected the argument that the need to plead with particularity has some impact on the accrual date, and said that the safety valve there, if there is one, is equitable tolling. With that, I'd like to turn to equitable tolling. These plaintiffs cannot allege facts sufficient to rely on equitable tolling here.
What do we do with U.S. versus Kubrick, the Supreme Court case from 1979 that says, under the federal common rule, that there is an injury and you must know who committed the injury for the accrual date to begin running? And so the argument I'm hearing from counsel is the accrual date could not have started in 2018 when the injury occurs because we still don't know who committed the injury.
Well, they certainly knew by description who the defendants were. They say it was the SIBO designated SPX option market makers. And I think the argument that's being made is for something that comes down to a name discovery accrual rule, but there is no such rule. Yes, I acknowledge there are cases that talk about knowing who injured you, but reading those cases, what they actually establish is that you have to know the source of your injury. For example, they rely on the Schaefer case out of this court, an old case from 1975. But the situation there was that some of the defendants had been indicted and those were sued because their involvement in causing the harm was known. It was much later that the involvement of a whole different set of people came to light. And so accrual was deferred as to those people whose involvement in causing the injury was known. It's quite different here. They knew who the people were by category. They just didn't know their names. And that, if there is an escape from it, is an issue for equitable tolling.
Is that sufficient?
Not accrual.
Just the category, is that sufficient?
Absolutely. Under the case law, if you know the injury and you have a sense of the source, then you have to find out within the limitation period. And that's, I'd refer the court to this decision, this court's decision in CADA 920 F. 2nd at 451, where the court says equitable tolling is the remedy for someone who cannot obtain information necessary to decide whether the injury is due to wrongdoing, and if so, wrongdoing by the defendant. So on the equitable tolling side of this, I would like to take the court through the actual chronology of what happened, because the argument that's being made is that the district court shut down any Doe discovery because of the PSLRA stay that was in effect in the class action. That's just not true, and it's not supported by the record. So first of all, LJM in January of 2019 comes in with a very broad request for discovery that it labeled Doe discovery, but in fact sought discovery into how the VIX was calculated and information to allow LJM to discern the strategies of the entities that had placed those quotes. There was a hearing, and the transcript is at DSA 74. The district court said, I have a strong interest in making sure things are coordinated and people aren't trying to do an end run around a system that we have in place to get to the bottom of what's at issue in this case and in the MDL, which is what was going on with the VIX process and was there manipulation. The problem was not breadth, the problem was not that there was a stay, the problem is that this was merits discovery. Then I acknowledge March 2019, LJM docket number 22, which is partially quoted in the reply brief. The full quote is, based on the current posture of LJM partners, discovery will not be permitted in that case until I conclude that Doe discovery in the class action is appropriate. But no one understood that to mean that there was a definitive ruling, no Doe discovery, while the class action motion to dismiss remains pending, including LJM, because in June, when the PSLRA stay was still in effect in the class action, LJM comes back again and renews its request. There's a hearing, again, the transcript is in the record, DSA 107. The district court again is clear that it is not blocking Doe discovery. Its problem is with the kinds of information that LJM was seeking. LJM at DSA 105 acknowledges, we want this data to determine whether or not there was anomalous trading happening during that period of time. The district court asks, is what you're asking for really the right way to find out who those does are? And then the district court issues an order, the August 2019 order, and denies that second request because it's seeking, quotes, extensive merits discovery. Enough information to glean the strategies of market participants so that it can apply the label of manipulation to specific does. This is not a case where a plaintiff simply needs to cut and paste an identifiable name into an existing allegation. And the last piece of this chronology that's also very important and very telling, which is that when LJM and Two Roads come back in February 2020 and finally make the request that was granted, which is not just narrower, it's an entirely different kind of request, a three-stage request. Yes, the PSLRA stay had expired by that point. There is no reference to that in their motion. And wouldn't you expect that to be there if they genuinely thought that the PSLRA stay was what had precluded doe discovery in the past? It's all about, this is a new process we've come up with, and they even say plaintiffs have followed this court's directions and prepared a narrowly tailored request, and they cite back to the August 2019 order for that. And so the idea that it was the PSLRA stay that prevented the doe discovery is just not true. I'd like to talk about the standing of LJM, if that...
Let me ask you a question about that. So there is an appendix to the complaint, and it does explain how LJM works, how it gets its profits, what its management strategy is. Why isn't that information, we can consider information attached to a complaint? Why isn't that information plus what we see in the complaint about LJM's role sufficient to show that it did lose money when this manipulation that they allege took place?
And the argument that's being made is really untethered to anything in the complaint. The complaint does not allege that LJM suffered some consequential business injury, which is what counsel was arguing this morning, and I think is what Your Honor is alluding to. There is a passing reference in the context of a sentence that actually is talking about the trading losses that the investors suffered, and all it says is that LJM would not have suffered these extraordinary losses and would have continued to operate as a going concern. So there really isn't squarely an allegation that that injury ever took place. It also wasn't argued below. And I'll say this finally on that point. Even if there had been an actual allegation of consequential business harm to LJM, that's not the injury that this lawsuit is seeking to remedy. And separately, that is not a harm that is remediable under the Commodity Exchange Act anyway. And so it wouldn't give them either Article 3 standing under TransUnion, because there is a mismatch between the injury that they are asserting for standing and the injury they're trying to remedy through this lawsuit. Separately, they would lack statutory standing under the CEA because they did not trade for their own account.
Can we, I think the argument that LJM is making, well, part of it, if I understand correctly, is that under the standard, under Rule 12, we can reasonably infer that because LJM is a general partner in a limited partnership, that it has some business interest in that was injured when the partnership itself had to dissolve as a going concern, whether it's business reputational harm, future profits they would have gotten had the company been going forward. What are your thoughts on?
Well, they had, under the case law, an obligation to plead facts clearly establishing every element of Article 3 standing. If those facts are true, they are well known to LJM and could very easily have been alleged. They do not appear in the complaint. They really can't be fairly inferred from what is in the complaint. What they're really asking the court to do is to speculate based on a handful of words sort of cropped from different places in the complaint. It's just not enough. And what they do allege is contrary to the idea that they suffered certainly an investment injury. They described themselves as the general partner. That doesn't tell us what their interest was. They described themselves as an advisor and a manager. And it's also concerning, to say the least, that different LJM entities are suing the futures commercial merchant in New York, claiming that it was they that suffered the injury that is being the subject of this lawsuit. And we're not asking the court to decide who's right. The point being that the failure to plead injury here appears to be concealing a real problem with the standing of this plaintiff. If I could finally address briefly the alternative grounds for affirmance. First of all, Scienta. The complaint really boiled down does not plausibly support the narrative that exactly the same time 8 separate market makers independently decided to manipulate the VIX by engaging in exactly the same misconduct. What we have instead, and it's in the reply at page 14, instead of facts, what we really have are just pejorative labels and conclusions, spoofing, flashed spoofing. But all they really point to is the duration of the quotes, and under the court's decision in Kosher, standing alone, the duration of a quote does not plead spoofing. On reply, they pivot to repetition as the problem. In their reply brief at pages 5 to 16, they even append some charts that purport to show quote repetition by 2 of the defendants. But even on the face of those charts, the quotes are not repeated. The level changes over time. And so, again, we really all what we have is rhetoric and labels unsupported by the facts. And what is in the complaint undercuts the rhetoric, because there is an obvious alternative explanation, which is that all of this is happening during a day when the US equity markets are suffering the kind of turbulence that they haven't seen in years. You know, they point to the fact that on a closing day basis, the S&P was down only above 4%, but materials that are quoted in the complaint reflect the fact that during the trading day, and recall that this is an index that is published every 15 seconds during the day, the Dow had its most violent dive in record, off 1,500 points at one point. And finally, on causation, they do not plead that either. Based on the reply, they seem to have given up on the idea that the defendants manipulated the VIX, and the VIX had an impact on the instruments that they were buying on a different exchange. And I know my time is up, but at page 23 of their reply, the plaintiffs perhaps inadvertently revealed the detail that they would need to have pleaded to establish that the manipulation on the CBOE flowed through to the instruments that they was trading on the CME. None of it is there. If you look at the paragraphs in the complaint that are cited in support of this, all it says is that as a general matter, these are broadly comparable instruments. That's no better than what the Second Circuit rejected in Harry, which is just saying it's the same market isn't enough.
Okay.
Thank you, Your
Thank you,
Honors.
Mr. Davies. Ms. Lawrence?
Thank you. First of all, we patently disagree that the only way to save this case is through equitable tolling. I would refer the court to the Supreme Court's Merck decision. Also, the fact that counsel claims that we could have just listed market makers and that would have been enough is belied by his own statements, where he stands up here and complains that the allegations that we made specifically about the 8 market makers aren't enough. If those aren't enough under their definition, then by no way a complaint naming market makers would have survived. So this is sort of the trap that we've been set up into. As far as equitable tolling goes, I'm glad counsel brought up the hearing transcripts that are in the record. The judge said in the first hearing that he was sensitive to the statute of limitations because it was raised, but ultimately he was more concerned about coordination and avoiding tag-along cases. In the August 2019 record, he then said, again, he was aware of the statute of limitations, but it did not outweigh his coordination concerns. So the record is clear that the concern here was about coordination with the MDL and not about the overbreadth of the subpoena. And lastly, I would just point out that as to Two Roads, again, we were monitoring LJM and seeing if we could do anything. It was clear that until that stay was lifted, we could not. Once the stay was lifted, we worked with an expert. There's expert analysis in our complaint, and also to craft the motion for expedited discovery.
Thank you, Ms.
Your
Flores.
Honors.
And Mr. Cortazar? Mr. Cortazar, a judge asked you a question at the very end, so we'll give you a full minute.
Sure. So I have 2 points to make. Number one, on the standing issue, the defendants never addressed Lexmark, and their entire argument rests on a statutory standing argument that Lexmark completely wipes off the map. I also want to provide some clarity on the accrual rule. Judge Lee mentioned the injury accrual rule. If the Supreme Court's case in 2019 very clearly distinguishes between the injury accrual rule, which it more or less rejects, and the fraud-specific discovery rule, which it identifies in Holmberg versus Armbrecht and Bailey versus Glover. That's the rule that this court applied in Schaefer. And in that case, the defendants did not know the three of the defendants' identities until after the court had lifted a discovery stay that was pending while a parallel criminal case was being prosecuted. And so the defendants, or the plaintiffs in that case, they had their theory of recovery. They knew a ton of facts about the manipulation scheme because of the indictment in that case. They even knew some of the defendants, but what they did not know was the names that came up as a result of depositions that was stayed as a result of court discovery. And so that's very much what happened here. You have a manipulation claim, you have a theory, but you don't have the identities and you don't have the facts underlying the fraud until the court lifts the discovery stay and the defendants produced, and SIBO produced the relevant information that we used to establish those facts. Thank you.
Thank you. We thank the parties, and we'll take the case under advisement. We now call appeal number 23-3151, Taylor versus Schwartz-Huber. Okay, Mr. Thompson.
Good morning. You know, Mr. Taylor, when he was stopped back in December 21st, 2015, believed that he lived in a free society, and the law at that time established that he did, in fact. In 1968, our Supreme Court decided Terry and said, "No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others unless by clear and unquestionable authority of law." This court, in United States versus Street, said about Terry, an investigative stop under Terry imposes a substantial intrusion on a person's liberty and dignity. Terry stops cannot be taken lightly. Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. It is a serious intrusion upon the sanctity of the person, which may inflict great indignity and arouse strong resentment, and is not to be undertaken lightly. the law was clearly established well before this incident took place. The magistrate judge below erred in not granting Mr. Taylor summary judgment on its Fourth Amendment claim.
Mr. Thompson, why didn't you move for summary judgment?
The local rules do not require a specific motion for summary judgment. The local rules tee up under Rule 56. Parties put in facts. Both sides put in facts. And we made the argument that we were entitled to summary judgment in our summary judgment briefs. We did not file a separate motion, but we responded saying under the facts, we were entitled to summary judgment.
Mr. Thompson, do you see the distinction between a line and a response saying you should give a summary judgment and an actual prepared motion with a memorandum in support requesting summary judgment with the reasons for the court and the law that you have identified as clearly established?
We asserted everything in our response brief and our facts that we would have had in a motion. We argued on the merits, not only at summary judgment, but subsequently on the scope of the trial. I mean, we had, for all practical purposes, we thought there was an absolute agreement with the magistrate judge and the city that the only issue that was going to be tried was damages for the unlawful detention.
But you didn't file a motion for judgment as a matter of law either, right?
No, well, that's the same thing. We didn't make a motion under Rule 50, right? Because we argued on the merits, both when we filed the motion on the scope and then in motions in limine. I mean, essentially 3 times we argued the exact issue, whether or not under these facts.
But the question is, has this argument been waived? That's really the heart of what we're
I think absolutely not.
Okay.
We did everything we could to raise it.
Except file a motion
What-
for summary judgment.
No. We
And
asked
we
for
didn't
summary
file a
judgment.
motion for, you filed a response and alerted to 56F.
That's
You
right.
did not file a cross motion for summary judgment.
No,
You did not file a motion for judgment as a matter of law under
That's-
Rule 50.
That's true.
Okay,
That's true.
so has this argument been waived?
I do not believe under the facts and under the law, procedural law, that there was any waiver. We were before the magistrate judge on summary judgment and said under these facts, Mr. Taylor is entitled to judgment. We argue alternatively that it was a jury question. That is legit. I mean, we cite the case, this court has said that we're able to do that, but there isn't a specific requirement that we file a separate motion under Rule 56 if we believe that the undisputed facts give Mr. Taylor the case. So I do not believe that this is waiver, because we spent much time with the magistrate judge discussing that under these facts, Mr. Taylor was entitled to a judgment, and that the only thing the jury had to decide was damages. So the essence of this case, and that was argued consistently throughout, is that officers cannot see a young black juvenile running with a bag.
We use this word a lot, juvenile, throughout the briefing, throughout the papers. And when we look at the legal definition of a juvenile, what would have characterized this black 16-year-old running in his neighborhood as a juvenile?
I think, you know, common sense, having kids myself, when my kid was 16, he's a juvenile, he was a kid. I mean, does a kid
Yeah.
running with a bag 3 days, 4 days before Christmas, taking a turkey to the neighbor, should that person be stopped
Well, there is
for just running?
there is law, isn't there, in our circuits, or other circuits, that talk about, you know, in a what they call a high crime area, if police officers see someone fleeing from them, that given the circumstances, they may have reasonable suspicion sufficient to at least do a investigatory stop.
I'm glad you asked. The only evidence of record where the two officers said that their supervisor had told them previously that there were some armed robberies in the neighborhood by juveniles. The day they went out, there were no calls for robberies. There was nothing specific. There was nothing specific that this is, so in quotes, you know, high crime area. All they had was a young person and some general claim that it was a dangerous neighborhood.
The officers also, I just want to make sure I understand the record correctly. The officers also, from their perspective, said that they saw Mr. Taylor look at them, see them, and then speed up, right? And I take it that Mr. Taylor himself contests that version of the facts.
I think one thing that the magistrate judge said at record 34 said the officers were not responding to any crime reported that day. They have not provided any facts about the past robberies in the area. The officers have not described anything suspicious about the object itself or how Taylor was carrying it. They simply didn't know if it was a bag or a backpack. The officers did not observe Taylor run away from a store, a person, or a vehicle. They did not observe him cutting through private property. They did not observe Taylor check behind him as he ran. And Taylor was running fast because it was cold that day. Now, there is a dispute. Mr. Taylor said that he never sped up. The officers said that he sped up. I say that is not a material fact. Because if you're just running, he wasn't fleeing. The cases that the court alluded to is where there is someone fleeing from the officers.
Well, but doesn't fleeing depend on whether or not the person that's running noticed that the officers were there? I mean, because as I recall the record, Mr. Taylor says that he was, first of all, he contests that he was sprinting, or he doesn't say he was sprinting. He said he was just jogging. And he also says that he never looked to see the officers. And in that situation, if you take his word for it, then I think that you may be right, that that doesn't amount to flight. But the officers say that they saw Mr. Taylor glance at them, and then when he glanced at them, they sped up. Now, I understand that there's a dispute of what happened. But given the fact that that dispute goes to whether or not a reasonable officer can consider, whether or not there was flight after seeing the officers, wouldn't that dispute be material to the determination of whether or not there would be qualified immunity here?
No, I don't think so. Because the qualified immunity was clearly established, and there's no question, and the court found below that there was no qualified immunity for once they knew that the turkey was in the bag, that there was no qualified immunity. But here's the important thing. These officers, Officer Radzewski, had made a determination on a young black man running, and he was going to run a warrants check. That decision was made before they ever got out of the car. They immediately asked Mr. Taylor, they frisked him, asked him if he was high, asked him whether he has a gun. Officer Shortberger is looking in the bag and sees the turkey.
What's the constitutional violation?
I think there were 3 as a matter of law that they violated. And I think there's a jury question on the equal protection. There was no reasonable suspicion for the stop. 2, there was no no basis for the pat down and frisk. And there was no basis for the continuing detention, putting him in the car and running a warrants check. Because the video itself establishes that the officers had discussions outside the car before they got in where Mr. Taylor was being held, that there was the turkey in the bag.
So isn't there a factual dispute, going back to Judge Lee's question, as to whether or not there was reasonable suspicion to stop the young man as he's crossing the street?
Under these facts, I think as a matter of law, a young black man running does not give rise to reasonable suspicion.
It's not the running. It's when, if you listen to the question, Judge Lee was asking, did the young man see the police and then speed up? In essence, did that turn into fleeing from police? Is there a factual question there?
I would frame it this way: in the context of what the officers had already decided before they did anything, they had made a decision to stop and run a warrants check on him. They made that decision several times, even after they found the turkey. They called in, there were no records for this, right? The only thing we have is the CAD report, and it says black male suspicion. We know that call went in after they had already seen the turkey. And at page 33 of the city's brief, they say that Officer Ridlewicz knew on the sidewalk about the turkey. We know that there's no dispute that Schwartzberg. So the question is, when they know all they have is a turkey, and they know the kid has taken it to the neighbors, there's no legal basis to run a warrants check. None.
Okay, Mr. Thompson, you're into your rebuttal time.
Thank you.
Ms. Williams?
Good morning.
Good morning.
May
You
I
may
proceed?
proceed.
May it please the court, counsel. This is a challenging case to respond to in large part because a number of the issues raised by Mr. Taylor here today were not preserved for appeal, and thankfully the trial court record supports the decisions made by the
I don't
district.
know if it does, because you don't include a single citation in your fact section. And you don't include any assertions that, you include quite a few that don't appear or accurately characterize the record. I just question, what do we do with your fact section?
Well, I think that the city's factual background section in pages 2 and 3 of our response brief doesn't include those citations that are required. Even if you strike that section from the brief, which is suggested by, let's see, Gross versus Town of Cicero, there is sufficient citation to the factual record in the argument sections when we reference facts to support the city's position here today. So if I
The
can't,
first one that I have is, it says in your brief They were assigned to patrol the area because of ongoing armed robbery offenses by juveniles that were occurring at a high rate on Capitol Drive due to the holiday season. But the evidence at trial doesn't support that. If we look at docket 64, which is the sentencing transcript, it actually says there had been some robberies and armed robberies by juveniles in the general area. Is that correct?
In the general squad patrol area that they were assigned, that's correct.
All right. And so I don't see anything in the record that supports the characterization that there were ongoing robberies.
That day, Mr. Taylor is right. There were no active,
All right.
fresh calls.
I
for
don't
robbery.
see any support in the record that there were robberies occurring at a high rate.
This is outside
Is
the
that
record.
correct?
That is not in
All
the
right.
record.
And I don't see anything in the record that says that this was due to the holiday season.
There is some discussion in Officer Rajetsky's testimony that I took about the captain's car assignment to patrol specifically for armed robberies that had increased during the lead up to the Christmas holiday on December 25th.
You say that in your brief that the Taylor looked at the officers and increased his speed. We spent a lot of time, you heard, talking about that just a moment ago. But at the trial, no one testified that Taylor sped up, ran faster, or increased his speed.
That's correct.
All right.
And that's
So the next question is, the officer testified that when he spoke to when he said stop, that the young man stopped immediately. Is that correct?
accurate.
So if there's no, in the record, there's nothing to support the government's allegation that he looked at the officers and increased his speed, are we able to rely on that?
I want to go back to Terry versus Ohio.
I want to go back to what you've presented to the court as the facts. And so can we rely on the representation that the government has made to the court this morning that Taylor looked at the officers and increased his speed if there's nothing from the record that supports it?
If that were the only fact, then yes.
All right, so my next question, it says that Taylor was holding a large bag, a large bagged object, but I don't see any support in the record that either the bag or the turkey that it contained was large. I see that what everybody agrees is that he was running with a bag that had a turkey in it.
I think the reasonable inference is that turkeys are large. Frozen turkeys that we prepare at Thanksgiving and Christmas are usually the large ones, and so the reasonable inference supports that assertion.
The last one that's concerning, it says that Taylor's manner was suspicious, and that's what piqued the officer's attention. I don't see anything in the record that says that anyone testified about Taylor's pre-stop disposition.
It is in the record in Officer Rajewski's testimony, and that is in document 71-1, pages 103 through 107.
And what does he say?
He says, and this is why that eye contact and the increase in speed alone does not carry or lose the case. The officers
That it doesn't appear. It didn't occur below. But go ahead.
So the officers testified at trial, Officer Rajewski specifically, that when they first observed Mr. Taylor, he was running and crossed Capitol Drive, which is a major thoroughfare in Milwaukee, at a time when there was no traffic. This caused them to notice him. And they testified at trial in agreement with Mr. Thompson that running alone is not a crime. But they watched him as he ran across the street, and what they thought was, is he running from something? Why is he running? It's clear to us that he's not exercising or jogging at the time. So they decide we don't have
What is it about his manner? That's what you represented in your brief, that the suspicion was piqued by Taylor's manner. And if it wasn't him running, what is it about his manner?
It was the flight path and the direction he was running at a time of night when there was nothing to indicate why or what he was running
So if he was
from.
running south versus north, that would have been I'm trying to follow the argument.
The argument is, as they first observed Mr. Taylor, they noticed him because he's running in an area, not clearly exercising, and not running away from
How
something.
do you know
or-
this young man is not exercising, running down the street in his neighborhood?
Well, I have to get there. So as they watch him, and what they conceded at trial was they had no basis at that moment to stop him. And what happens is, as they watch him, consistent with their assignment to do this robbery patrol, targeted kind of patrol, is they watch him, and as he runs across, he runs in front of their squad and they almost hit him. So that, on page 107 of document 671 in the trial court record, that sudden movement into traffic confirmed that their suspicions, in conjunction with the observation as they're watching him, that he's carrying something in his hands. So that was the trial testimony from Officer Rajewski explaining their reasonable suspicion and the
So what
observation.
made him suspicious is that there's a young man running at night with an object in his hand.
That is not the extent of it. If that were the extent of it, this would be a problem.
I'm still
consistent
listening for
with-
something else then, other than what you've just described to me, is that he passes police officers and he continues running with an object in his hand.
in the context of the description that the officers had from their supervisors, which directed the mission they had that night.
Stop juveniles if you see them running with objects in their hand.
That robbery victims were reporting that robberies were occurring conducted by juveniles who happened to be African American. And this was also explained in the trial court record by the
Is that
officers.
not a blanket then to stop every African American young man running?
Absolutely not. Absolutely not. And now that in hindsight,
Because in what we have that the officers had was that from the testimony, from the trial, because that's what we have is the record, is that Taylor was perfectly cooperative, that Taylor was polite, and that he eventually began crying when he was placed in the back of a squad car.
accurate.
And so you represented that he was put in the back of the squad car due to the cold temperature. That's nowhere in the record. Instead, I have the officer's sworn deposition testimony that said they placed him in the back of the car for a few minutes to see if there were any new fresh robberies reported. Where do we get a basis that he was placed in the squad car due to the cold temperature?
I remember that this was testified to during the 2 days of trial.
That's why some citations in a factual section would be useful over and above the fact that it's required. There's a larger problem. Judge Pryor asked you a series of facts, and the facts are not in the record. I think only one of them you were able to respond that it was in the record somewhere and hadn't been cited to, but it's an overall credibility problem with the city's brief.
I think this goes back to what I was saying in the beginning, and with the equal protection claim that was dismissed at summary judgment, and also the application of qualified immunity, a lot of the issues that could be ripe for appeal now are along those lines. And the problem with the city's brief is apparent, our failure to cite to the record. But that doesn't resolve the issue that the city was deprived of making any contrary arguments when, as Mr. Thompson says, he moved for entry of judgment as a matter of law multiple times through a motion in limine.
Ms. Williams, I think that, what we, from our questions, probably apparent that what we're kind of really focused on is the initial stop, right? And what I'm troubled by is the qualified immunity, summary judgment granted to the city with regard to that initial stop. As you know, a court on summary judgment, when it comes to qualified immunity, can't resolve disputes of fact, right? If there are disputes of facts that underlie qualified immunity defense, that has to go to the jury, and then afterwards, the court can decide that question. What is your best factual argument based upon undisputed facts, right, that would support the qualified immunity given to the officers for that initial stop?
I think it goes down to the second prong of qualified immunity, the clearly established. And what I would like to note is that Terry versus Ohio gives us a standard that officers, in order to conduct a field interview, stop, and even a pat down, are required to have reasonable suspicion.
And we're as you might imagine, we're very familiar with Terry. There's also cases in this circuit where just because you're in what's called a high crime area, it doesn't mean that you can prophylactically stop everyone, right? There has to be some additional indicia, for example, flight, which is why we're focusing on flight. But there seems to be a dispute of fact as to whether or not Mr. Taylor's running opposite the direction of the police car was due to flight or not. And so I guess that's why I'm asking you, based upon kind of the undisputed facts, what is the city's best case that this would qualify?
I want to direct the court's attention to United States versus Weathers, which is a Seventh Circuit decision. Actually, it's a district court decision, excuse me, where the facts are somewhat similar. There is a man who is walking down the street, and he's kind of like looking in places. He's maybe acting according to the officer's observations from their perspective, which has their training and experience bias built in. They're there for a targeted armed robbery patrol because people had been reporting that they were victims of armed robbery having exited bars while they're intoxicated. A great scenario for a robber and a victim. What's interesting about U.S. versus Weathers is at the very end of the decision, the court points out that the calls for service, the brief interaction where the victim was able to provide a general description of who was robbing them, were specifically for suspects who are white or Hispanic. Mr. Weathers did not fit that description. As general and vague, unfortunately, for victims of armed robbery that can provide, Mr. Weathers was African American. So he didn't even fit that vague general profile provided by victims of those crimes. With that, my time is up, unless the court has other questions.
Thank you.
Thank you.
Mr. Thompson, let's see, we'll give you 2 minutes.
Thank you very much. What troubles me the most about this case is we did not file a Monell claim. We referenced that the ACLU had filed the Collins case, and that set up this whole issue of what kind of records are the police going to keep in Milwaukee. What's troubling is, then Chief Judge Clavert had looked at the Dantzler case, and he had summarized with the case out of 2006, where there was just no reasonable suspicion and the law was clearly established. When I've looked at these facts over and over again, at the end of the day, I only have a black male as a reason for the stop, period. Because the call comes in and says black male suspicious. And what we learned through trial,
You did not move for summary judgment in your favor on the Fourth Amendment claim. So for your equal protection claim, what's your best evidence of discriminatory effect?
on the issue, the Rule 59, we asserted after the trial, again, revisiting the case, that it's manifest error not to find a violation of the Fourth Amendment as a matter of law. On the equal protection, the best case is that at the end of the day, when they put Mr. Taylor in the car, they knew they had no suspicious activity, period. I don't think there was any reasonable suspicion ever for the stop to begin with. But when they put him in the car, they were going to run the warrant check, and they had decided that already. And the court made the notation. They put him in the back. They were hoping that calls would come in. Now that would tell me that this was pretextual to begin with, and now they're looking for a way to justify the stop. But all we have is a black male being held and a warrants check on him, hoping something comes in. That is, I think, prima facie to go to the jury. Because at the end of the day, there is no reasonable suspicion. There is no suspicion other than a black young man running. Thank you.
Thank you, Mr. Johnson. We'll take the case under advisement. The court will stand in a brief recess. All right, we are back with appeal number 3399, USA versus Douglas. Mr. Patton.
Good morning, Your Honors. May it please the court. I'm Tom Patton, and I represent the appellant, Ryan Douglas. The two warrants at issue in this case, the house warrant and the cell phone warrant, are examples of how not to write warrant applications. Neither warrant establishes probable cause. This court needs to say as much so this practice can stop. Probable cause isn't a particularly high standard. I understand that. But it is a meaningful standard. It is the standard that separates our citizens' privacy to their home and to their person, to their cell phones, from government intrusion. And neither warrant in this case established probable cause. And the district court went wrong in allowing speculation to take the place of inferring reasonable inferences drawn from facts. The only thing that linked the house to any drug activity was that Mr. Douglas briefly went there after the controlled buy was set up. Now, clearly there was probable cause to believe he was selling drugs. They'd done buys from him.
Well, didn't he also stop by this house before he went?
He did. When they set up
So,
this...
hold on. So he gets a call. He goes, be right there. I'm at the store.
Mm-hmm.
He goes to the house, comes out, goes to the controlled buy, then goes back to the house.
That's right.
Right? Okay.
That's the only connection to the house. You know, they don't say he lives there. They don't see he's been there before. They don't say the black BMW has been seen parked there before. Nothing. As in like in Yarborough where they said, hey, after 2 controlled buys, he goes back to this place. We know it's his girlfriend's place. We know his car is registered to his girlfriend.
The facts of Yarborough, there are more facts in Yarborough than we have here. I take your point on that. You suggest that an affirm would mean that the officers can search any place a defendant goes after a drug deal. And you do have this point in Yarborough that says, you know, it wouldn't be quite right to just search any place a defendant goes after a drug deal. Is that formulation too broad based on what we have here? Because the officers didn't search just any place he went to after a drug deal. They searched the place he went to after a drug deal, which also was the place he went to right before the drug deal. Yeah. Should that make a difference?
I don't think that's a material difference because the idea is look, people that engage in crime sometimes will stop by other people's houses or other places, right? And it's not like they had him under surveillance from the store and they say, oh, he went straight from the store to this location, to the buy, and then back to this location. I mean, for all they know, he stopped somewhere else, you know, in between leaving the store, or that he had the drugs while he was at the store, right? Because the only constant through all of these was the black BMW, right? And so it is that, because the probable cause standard is there's got to be probable cause to believe that evidence of the drug dealing is going to be at the house, that there'd be a probable cause to believe that he would store stuff at the house, that he would keep stuff at the house.
So
right?
Would their argument be stronger if they actually surveilled him on the path from the store to the house and saw that he only went from the store to the house as opposed to potentially, as you mentioned, stopping somewhere else?
I think it'd be stronger. I would submit it wouldn't be enough because unless they had a longer term surveillance on him, because again, we know he's dealing drugs out of the black BMW, right? That's the consistent through the 2 prior ones and then what they observed on the day in question. And so there's just not enough of facts. There are not enough facts to draw a reasonable inference that he has any more connection to this house than he just stopped by there one day, that he knows some people that live there. He stopped by there, but hey, in the process of going out there for the day, he gets a text from somebody saying, hey, you know, can you get me a couple ounces? And he's like, yeah, all right, well, I can do that because I got the stuff in the car. So, you know, I'll drop by, you know, stop by, drop my stuff off, go do it. And that's the problem with the warrant. There's not enough connection to the house to draw the reasonable inference that there is probable cause to believe evidence of drug dealing is going to be at the house. They never say it's his house. They never say whose house it is, that he has any other connection to this house than he happened to go there on the day where he does this controlled buy. And yeah, he goes there before and after, but again, that doesn't distinguish anything that, or raise any reasonable inference that he stores stuff at the house, or that that's where he's doing his business out of. That it's nothing that, hey, we think it's a stash house for him. Or we've seen, at least in Yarborough, they said, look, we've seen this car that he does all the deals with at the place on other occasions. We've staked the place out and seen it on 3 different occasions, not linked to controlled buys, where the car's at the house. So you then have the reasonable inference, oh, it's his girlfriend's house. The car's parked there a lot. He goes there after multiple controlled buys. Here, there's just nothing like that.
Let's turn to the phone.
Sure. The phone is even worse, because if this affidavit is good enough, then Riley means nothing, right? Because Riley says, we are not going to let you search a cell phone simply because a person who gets arrested for an offense has a cell phone on him. That's the whole point of Riley versus California. The only thing this affidavit said was, we did a controlled buy off of him, and we arrested him, and he had a phone. Now look, yeah, the controlled buy was set up using a cell phone, either through a call or text message. I don't deny that. He says, I'm at the store. But as we point out in the brief, the government goes in front of juries and judges and courts all the time and says, hey, drug dealers use multiple phones, they use burner phones, it's a tool of the trade, right? And when he gets arrested in the car, they search the car because they tow it and everything. There's no drugs in it. There's no drugs on him. So there's no evidence that at the time he gets stopped, he's engaged in drug dealing. So there's no reasonable inference that the phone he has, which according to the affidavit, it could have been, because they used the within the 72-hour language, as far as the judge issuing the warrant knows, it's been up to 3 days since the controlled buy happened. That, hey, 3 days later, he gets caught driving the car with no drugs, no evidence that he's engaged actively at that time engaging in drug dealings. But hey, he's got a cell phone on him, so let us search the phone.
The cell phone was contacted on 2 occasions.
Yes.
2 controlled buys, right? So it wasn't just the time that he was in the store and they stopped by the house. There was another instance in February of 2018 where the CI contacted that phone as part of...
They didn't know he contacted that phone. They didn't do any investigation to link the phone they asked to be searched to the phone that was contacted. We make the point in the brief. All they got to do is call the number, right? Because the reason we know it's the same phone is the search warrant affidavit literally puts the phone number from the earlier controlled buy that you're referencing in the controlled buy here. So they've got the phone seized, right? It's not a search to call the phone, to dial those numbers, see if the phone rings.
Oh, so you're saying that they had no idea that the phone that they confiscated and searched was the phone that's affiliated or associated with that
Exactly,
number?
Your Honor. Exactly, Your Honor. And took no steps to try and determine it, right? And it just, look, drug dealers use cell phones to sell drugs. I mean, it's just, yeah, that's a
Why
given.
wouldn't the good faith exception apply to both warrants?
No, I would say not, Your Honor. And this
I
is...
said, but why not?
Well, number one, Riley versus California, I think, for the cell phone does it. In the Lindsay case out of the First Circuit that the government cites, I think, it admits that, hey, we can't have a rule that just automatically says you get arrested for drug dealing, you get to search a phone. But I think Riley versus California, period, establishes that. With the House, I think it is Yarborough that does it, and that this court's case opinions in Korth, I'm going to butcher this name, I'm sorry, Mike Kaidak, in Bell, they make the point that, especially for federal task force officers, they have a duty to know the relevant federal law because they work with federal prosecutors regularly. And look, there's a reason this 14-gram case ended up in federal court. It's because they knew, because these agents and the prosecutors talk, he was going to be a career offender. And they filed an 851 notice based on his prior Illinois cocaines to jack up the statutory maximum. You know, his career offender guideline was going to be 262 to 327. Now, Ruth knocked out the Illinois cocaine. So these local cops that are on the task forces, they talk with the agents. They know and need to know federal law. And I'd say Yarborough puts any agent on notice. Hey, just going to a house on the day of one controlled buy isn't enough. So we'd submit that there's not good faith for either warrant. I see my time's up.
Thank you, Mr. Patton. And Mr. Simpson.
Good morning, Your Honors. May it please the court, I'm Scott Simpson on behalf of the United States. As defense counsel has said, there's no dispute here that Mr. Douglas was involved in dealing drugs from his black BMW. So the only question here is connecting that activity to the house, to the 16th Street house, and to the cell phone found on Mr. Douglas's possession upon his arrest. First, in relation to the house, as some members of the panel have already mentioned, Mr. Douglas arranged a drug sale over the phone while he was at a store. Then he immediately drove from that store to the house. True, there was no surveillance during that drive, but it took him 10 minutes to arrive back at the house. He carried the results of his shopping trip into the house. Then he left right away and drove directly to the location of the drug sale from that house. And then after the sale, he drove directly back to that 16th Street house. The question here is whether there was a fair probability that evidence of Mr. Douglas's drug dealing would be found.
But in the other cases where we found a fair probability, there was more.
Your Honor, obviously there can be more. In fact, defense counsel says that the police should have called the phone that was found on Mr. Douglas's possession at the time. That certainly would have given more. But here we submit, Your Honor, fair probability, we're not talking about establishing beyond a reasonable doubt that the house is used for drug dealing. We're talking about just a fair probability that evidence of drug trafficking would be found at the house. And we submit that these facts strongly suggested that Douglas was using the house as a base of operations for his drug trafficking. Imagine you're away from home, say you're at a store, and your friend calls you on the phone and asks you to bring him such and such. And you say, I'm gonna quote the sentence from the affidavit that summarizes or paraphrases what Mr. Douglas said. It says, Douglas advised he was leaving the store and would be at the predetermined location shortly. And as I said, he arrived at the store after that call in 10 minutes. So imagine you tell your friend that, okay, I'll bring you this stuff, and you imply at least that you're going to do it right now. So where do you go after that call? You go to where you have the thing that your friend asked you to bring to him. So you go to your home, which is what Mr. Douglas did here. You go to where you have that thing that you're going to take to your friend. So Douglas clearly went where he was keeping his drugs. That's at least a reasonable, at least the fair probability here. And that's what we're talking about, only a fair probability.
Could he have gone home or to the house just to drop off the shopping stuff that you mentioned?
It's possible, Your Honor, but that itself would suggest that he had a connection to the house. And as this court has said, if we show that someone is residing at a house, that is also part of probable cause to suggest that the person has.
But then if it's his mother's house and he's going to drop off her frozen items that he bought at the store for her.
Maybe a turkey?
Mm-hmm, yeah. And then is returning there to finish checking on her after he finishes his drug deal.
That's possible, Your Honor. However, all the sequence here, the speed with which all this happened, and again, we're not talking about reasonable suspicion. We are talking beyond a reasonable doubt. I'm sorry, we are talking about
the question is, because there are so many possibilities. I mean, we could sit here all day and think of all the different iterations of what happened, what was that house perhaps. Should there be a floor of what we're asking of officers before they get a warrant? And do the rest of the cases, Yarborough, et cetera, establish a higher floor than we see here?
No, Your Honor.
Even sticking with the fair probability language.
And I wanted to address Yarber. Yarber, the defense's reliance on Yarber here puts us in kind of an odd situation. Normally, when we are responding to a decision that the defense is trying to rely on, when we are distinguishing a decision that they're trying to rely on, it's a decision that was decided against the government. But in this case, Yarber was decided in the government's favor. And as I think some members of the panel have already mentioned, there are some differences between this case and Yarber, and we would suggest that in some respects, this case presents facts that are even more strongly in favor of reasonable suspicion than Yarber. In Yarber, the defendant only drove to the apartment after his two drug sales, whereas here, Mr. Douglas drove to the house immediately before a drug sale and immediately after the drug sale. So in Yarber, you're looking at, well, maybe he didn't get his drugs from the apartment, but here, because he went to the apartment after promising to bring drugs, that supports an inference that the drugs were at the house. And here also another difference between this case and Yarber, whereas in Yarber the affidavit expressly said that Mr. Yarber lived somewhere else. It identified another apartment as his residence. Here there was no statement along those lines, leaving it open again the inference that, well, maybe he did leave there. Maybe he did live there. You also have the fact, one more fact here, you also have the fact that the 16th Street house, the house involved here, was located only about 2.5 blocks from the bar that was involved in the second controlled buy. Now, the state judge, this is a fairly small city, this is Quincy, fairly small city. The state judge may well have realized that they were in the same general area, that bar and the house were in the same general area.
Well, let's talk about the phone.
Certainly. Absolutely.
How did the judge know, the affidavit has the phone number in it, but how did the judge know that the number was linked to Douglas, the officer, I'm sorry?
Well, certainly, Your Honor, here we certainly know that Mr. Douglas was using a phone to arrange his drug sales. He was clearly driving around to do his drug sales. He was clearly selling from his black BMW. So you have the same number, the same phone number used for two of his controlled buys. It was clearly a cell phone, despite what the defense says in their brief. It was clearly a cell phone because Mr. Douglas took that call while he was in the store. He was obviously using a cell phone, not a landline. And then no more than 3 days after that last controlled buy, he was arrested carrying a cell phone with him in his car. Now, on this argument that the police could have called that phone, maybe they wish now that they had called that phone. I don't know why they didn't. But the fact that the police could have done more, could have gained additional facts to support reasonable suspicion, doesn't mean that we absolutely have to have that additional information. Officers could almost always get additional information to support reasonable suspicion. So in light of these facts, again, the fair probability, that's all we're looking for. In light of these facts, there was at least a fair probability that evidence of drug trafficking would be found on that phone that Mr. Douglas had upon his arrest. The defense talks about the fact that, and it's true, we see it all the time, that drug dealers use multiple phones. Here, that wasn't happening. Here, the evidence shows that that was not happening. Here, the evidence shows that Mr. Douglas was only using one phone. You have one phone number connected to two of his calls, and he had only one phone upon his arrest. That, again, supports the inference that that was the phone he was using for his drug trafficking. Finally, Your Honors, sometimes when I get to the point of good faith, I'm not sure what to say. Based on all that we've said, based on all that we've already said about the existence of probable cause, obviously this case, at least, if the court doesn't find probable cause, at least it is to be affirmed based on good faith. The opposite of good faith, of course, is bad faith, and this court has said that only on rare occasions, quote unquote, has the court found that officers acted in bad faith in relying on a warrant issued by a judge. The mere fact, as the court has said, the mere fact that they got a warrant, that they went to the judges, went to the judge and got 2 warrants, provides a presumption that they were acting in good faith. Certainly there's no basis for finding of bad faith. So for all those reasons, Your Honors, we urge the court to affirm.
Thank you. Mr. Patton, we'll give you 2 minutes.
Your Honor, the critical thing that Yarber says is that, Your Honor, there is a floor. And the floor is you have to have enough facts connected to a house to allow for the search of that house. And Yarber had the defendant there multiple times over a period of time. Some of those times not even linked to drug activity, just staking out the house. So you had a continuing connection between the defendant and that house. Here, they didn't do any of that. They just don't have any of it. If you affirm here, it's you go to a house the same day, somewhere in the middle of doing a controlled buy, that house gets to get searched. If you're dropping off groceries at your mom's house, or you're just going to some friend's house, as I put in the brief, look, if it's Sunday afternoon and you run in and you drop off a case of beer and then run out, do the thing and come back, it's speculation that you have some further connection to that house, not drawing reasonable inferences.
You mentioned Riley. Why isn't the best reading of Riley that phones are so important to our modern daily life now? If you want to search it, you have to get a warrant. Not that you can't just automatically get a warrant for everybody you want to search, and you don't need to have a reason for a warrant. Can you point me to the language in Riley, because I don't see it in your brief that is making the proposition that you want to make.
The point I'm trying to make in the brief is Riley clearly says you have to get a warrant to search this stuff because it has just an incredible amount of personal information. They did, but the warrant means you have to establish in the application that there's probable cause to believe that there is evidence of a crime on the phone. So if all you have to do to get the warrant is to say, we arrested him for a crime, he has a cell phone with him, well, people use cell phones. If he's getting arrested for a crime, they've got probable cause to believe that he committed some crime, right? That's what gives them the right to arrest him. If all they have to say is, we arrested him, he had a cell phone, so there's probable cause to believe he used that phone to commit the crime we're arresting him for, the warrant requirement serves no purpose, because in Riley, they had the phone because they arrested the person, right? And the question was, can you just search it incident to arrest? And like, no, you got to have some warrant to establish. And when you have to get a warrant, the basic tenets of a warrant is you have to establish probable cause to believe there is evidence of a crime on the phone. So it doesn't accomplish anything to put a judge in between the police and a citizen's phone if all the judge is doing is checking to see, well, did you arrest him for something first? That's the point we're making.
All right.
Thank you.
Thank you. Okay, we'll take the case under advisement. Thank you. Our next appeal is 23-2926, Sawyer versus Cotterman. Okay, we welcome to the bench Ms. Jensen.
Yes. Good afternoon, almost. May it please the court. I'm Sheila Genson. I'm representing the patient, Patrick Sawyer, in this case. And we're asking for a reversal of the summary judgment that was entered in favor of the defendants. I know you've read the brief, so I just want to hit a couple highlights. The The first one is, of course, is that we, as the plaintiff, we had to prove the deliberate indifference to a risk of serious harm. And there's not a disagreement here as to at least 6 ways to show that. It can be inferred from the facts and the evidence, and in this case, it was. We had not only the defendant's 3 deposition transcripts, we also had the plaintiff's deposition transcripts, we had medical reports, and we had the incident report that was authored by one of the defendants. That evidence shows that there was a deliberate indifference. We have somebody who was, and I just want to back up for a second, because between the defendants and the plaintiffs, we seem to be on a different plane.
What is the best medical evidence that you have that the defendants knew or disregarded a known risk to your client's health?
When he fell in the shower. There were 2 falls. He fell in the shower. He said, I don't know why I fell. I hit my head and my neck hurts and I'm weak. He said those things. I think anybody that watches any medical show, any football program, knows that when somebody hits their head and they don't know why they fell, you don't throw them in a wheelchair and wheel them a half a block and put them in a soundproof room and say, here's some ice for your head, here's some juice, have something to drink, and I'll come back and see you. It's beyond the realm of
Again,
common
that's
sense.
layman. I'm asking for medical. Other than I watch football.
Right.
I need some medical evidence.
I don't think there's anybody that would agree that that's a proper way to take care of somebody who has a head injury.
Motion for summary judgment. Okay? I'm not a doctor. And so for a medical indifference claim, you fell in the shower. And so if the evidence is because other people fall, it doesn't make good sense. I'm asking for what you're asking us to do on appeal, right? Is to find that there was enough here to get beyond motion for summary judgment. And so I'm asking for medical evidence. What is the best medical evidence that the defendants were or disregarded a known risk?
It's the medical records themselves.
Okay.
The other point that I wanted to bring up is that there was so much questions of fact here. And
So we have the medical records that say what?
The medical records that said that he had weakness, that he hit his head, that he had no known reason why he fell, and that he hurt his neck. Those are the medical records. And then what they did is, that was the nurse that was there on call, and then she called the doctor. And the doctor says, well, with all those things, and then, well, let me back up because the nurse didn't call at that point. The nurse didn't call until he had a bloody stool. I don't know if it's an hour at the same time or if it's an hour and a half later. It's unknown. Records are a little bit hazy on that point. But it wasn't until that point when the nurse called the doctor. And at that point, the doctor said, oh, with all those things, he must have hemorrhoids. Here's a man who's never been treated for hemorrhoids. And this is what they came up with. And they said, oh, well, you know what? Neck injury, headache, doesn't know why he fell, weak. I'll see him in a couple days.
Didn't Didn't the nurse perform a neurological examination after he got to the health center?
That's what the notes say. Did it really happen?
I mean, is there any reason to think that it didn't happen? That's in the record?
I think that the plaintiff would deny that that happened.
I mean, does he deny it in the response to the motion for summary judgment?
I don't think it's in the briefs.
And when Nurse McLaren first encounters Mr. Sawyer, the first when he falls in the shower, Nurse McLaren's testimony is that Mr. Sawyer seemed alert, didn't show any signs of acute distress, was able to stand and talk. I know Mr. Sawyer says his head hurt, right, and whatnot. But what is there anything else at that point that would alert Nurse McLaren to the fact that she needs to call 911?
She didn't want to listen to the plaintiff. He was trying to explain to her what his issues were, and she told him to shut up. So he didn't really get it out either, what was going on with him, because she didn't want to hear it. She was going off shift and she was going home.
Did we put any evidence in the record regarding the standard of care?
I think that Dr. Cotterman, I think he talked about the cause. I can't remember if offhand if he talked about the standard of care. But again, I don't think...
We do know why that's important.
I do. And again, I don't think that that's something that we can ignore the medical records when it comes to the standard of care. Because you're talking about, quite frankly, 3 people who completely ignored somebody, in my opinion. They didn't listen to him. He had complaints. I think the records are questionable.
But what are we basing that on?
I'm basing it on the fact that there's contradictions between the records and, for example, Nurse Brown's testimony. Nurse Brown said, "Oh, well, I checked on him. I told him not to get up. He was sleeping." Well, you can't tell someone not to get up out of the bed and if they're sleeping. That just doesn't make any sense. I think there's some controversy as to whether he had the bloody stool at 7 o'clock or at 8:45. I think the nurse said that they were going to check on him, but there's evidence that they didn't check on him for hours. I'd like to reserve some time.
Okay, thank you, Ms. Kinson.
Thank you.
Mr. Grady?
Good afternoon. May it please the court? Dylan Grady on behalf of defendants Dr. Cotterman, Nurse Franklin Brown, and Nurse Kayla McLaren. And we're here to ask the court to affirm the district court's, trial court's summary judgment ruling. And Judge Pryor, you hit on the main issue in this case is that there's a lack of medical evidence that plaintiff put forth to prove their case. Plaintiff has no medical training, and that he has no evidence that the care provided by Dr. Cotterman, Nurse Brown, or Nurse McLaren was improper. And
Are you conceding that his head injuries were serious?
correct, we do concede that his head injuries were serious, especially the last one where he fell out of bed and he was bleeding. The first one, serious, I would agree that for purposes of this motion and summary judgment, we were not contesting whether or not that was serious. But for that one, the first fall, the fall in the shower, Nurse McLaren arrives on scene and observes plaintiff standing around in the housing unit, walking around. He was alert and oriented. She then places him in a wheelchair to transport him to the healthcare unit. She doesn't ignore his symptoms. She doesn't disregard that his symptoms may be serious. She transports him to the housing unit or the healthcare unit in a wheelchair, and then she transfers care to Nurse Brown, who then performs a neurological assessment, determines that all that was normal, that there was no other visible injuries on Mr. Sawyer at the time.
Was it no other visible injury, or did it say no visible injuries? Because both can't be true. He can't be bleeding and not have any visible injuries.
Correct. Mr. Sawyer testifies that he was bleeding at the first fall, but the medical records do not support that. The steri strips and the bleeding
But
were
we
actually
accept that.
Yes, Your Honor. But even if the fact that that you may be bleeding does not mean you need emergent care. Again, Mr. Brown, Nurse Brown, assessed him, performed a neurological assessment, and provided care. He said he provided him an ice pack, provided him juice, he instructed him to remain in the bed and rest. He didn't ignore any of his symptoms. Even if there is a dispute about whether or not Mr. Sawyer was bleeding at the time, it's really immaterial to the deliberate indifference claim, because it's clear from the medical records that Nurse Brown did not ignore Mr. Sawyer's symptoms, right? He performs this neurological assessment, he evaluates him, he places him in the infirmary under 23-hour observation. They don't send him back to the housing unit. They place him in the healthcare unit at this point in time to be seen by the doctor on the next day.
So it's clear you do believe the defendants met the appropriate standard of care. What are you basing that on other than their own testimony?
Well, professional medical judgment, Your Honor. We have a number of both Dr. Codman, Nurse Brown, Nurse McLaren, all performed evaluations of
I said other than their testimony.
Other than their testimony, none, but the plaintiff was required to show evidence that defendants did not meet their professional medical judgment, and here he did not. A non-expert is not permitted to give expert testimony, and Mr. Sawyer was required to come forth with some evidence that the care provided by the defendant was improper, and he did not do that. And so we're left with either direct or circumstantial evidence, and even under a circumstantial evidence, there's no evidence in the record for this court to say that the care provided by Codman, Brown, and McLaren was a substantial departure from the accepted professional medical judgment. No one ignored Mr. Sawyer's complaints. Again, Nurse McLaren responds to the housing unit and takes Mr. Sawyer to the healthcare unit. She didn't assess him there and leave him there. Transferred to the healthcare unit, and Nurse Brown takes over, and he performs a neurological assessment, gives him pain medication, ice, juice, tells him to instructs him to lay in the bed. Again, nobody ignored Mr. Sawyer or sent him back to the housing unit, and Dr. Codman was notified and said he'd come in and evaluate him the next morning. No one was ignoring Mr. Sawyer's care and concerns, and so there is no evidence in this record for the court to find that the defendants did not use the professional medical judgment in evaluating and treating a patient with a head injury. And then when Mr. Sawyer fell again a second time while in the healthcare unit, as soon as he was found, he was, again, bandages were applied, steri strips to stop the bleeding, and he was taken outside the prison to the emergency room, where it was determined that he had 3 unknown medical symptoms, right? Salmonella, a membrane across his heart, and a cervical bruise or issues in his neck. None of these were known by the defendants, and there's no evidence that any of the defendants were aware of any of those symptoms prior to any of the falls or after the first fall. It's even unclear when or what caused those injuries, right? Again, because Sawyer did not present any medical evidence that he fell because of these undiagnosed symptoms, or that they should have been diagnosed in advance. Dr. Codman was treating Mr. Sawyer for Crohn's disease and anemia. But again, he was not ignoring those conditions. He was providing regular and consistent care, and reviewing the care, the totality of the care. Starting in 2019, Dr. Codman referred Mr. Sawyer to an outside specialist, a gastroenterologist, to track and follow Mr. Sawyer's Crohn's disease. And Dr. Kotteman implemented all those recommendations of the outside specialist. So, again, this case rests on the fact that the plaintiff, Mr. Sawyer, failed to present any evidence that the care of Dr. Kotteman of his Crohn's disease, his known Crohn's disease and his anemia was insufficient. There's no evidence in the record that Mr. Sawyer presented that any of the defendants were aware of these other conditions that existed, or that they should have been aware of these other conditions. Mr. Sawyer fell on August 10th, 2019. His last visit with Dr. Kotteman was 8 days prior, on August 2nd of 2019, where he was evaluated and determined appropriately to be placed in the housing unit. The deliberate indifference is missing because Mr. Sawyer failed to present evidence that defendants were aware or that their care was improper, and we cannot infer it based on the record. These are not broken noses or broken bones that were open and obvious. These are other conditions that were not obvious, and so we need direct evidence rather than the circumstantial evidence that is appropriate in other cases.
And even if the care didn't meet the standard of care, deliberate indifference requires more than that, doesn't it?
Correct. It requires a deliberate disregard of Mr. Sawyer's medical conditions.
A knowing disregard.
Correct. A conscious disregard. And there's no evidence of that. Each of the defendants, whether their care was perfect, that's not the standard. And this is not a negligence case. But were they providing care to Mr. Sawyer? Yes. Dr. Kotteman was following him, tracking his anemia, prescribing medications, informing him the proper doses of Imuron to take. Nurse McLaren evaluated Mr. Sawyer at the housing unit, transferred his care to Nurse Brown at the healthcare unit. And Nurse Brown performed neurological assessments, evaluated him. He observed this bloody stool, which, again, in the record, there's some dispute about that, but Nurse Brown actually testified that he observed the stool to be normal with a small amount of blood on top at 8:45 p.m. He called Dr. Kotteman. They discussed it and determined that based on the description that Nurse Brown had observed, that it was likely hemorrhoids, and that Dr. Kotteman would be in first thing in the morning to evaluate Mr. Sawyer. There's no evidence in the record that Mr. Sawyer presented that any of this care that was given by Dr. Kotteman, Nurse Brown, or Nurse McLaren was improper, or that it was the cause of any of his faults. Again, he presented no evidence that they were aware or should have been aware of any of these other symptoms that were discovered once he was transferred to an outside hospital, the salmonella, the membrane issue with his heart, and then the cervical issue. So for those reasons, we ask that the court affirm the summary judgment motion and the district court's decision. Thank you.
Thank you, Mr. Grady. Ms. Ginson, we'll give you 1 minute.
I just want to address really quickly some of the things that Mr. Grady had talked about. First of all, Brown did not check on Mr. Sawyer. He had a head injury and he was weak. He came in at 7 o'clock, whether 8:45 happened or not, but Mr. Sawyer stated that he fell out of bed, he was in a pool of blood, he couldn't move his arms or his legs, and he couldn't call out. They put him in a soundproof cell, and he watched the outside go from daylight to dark. So I have questions about whether 8:45 is legitimate or not. Furthermore, if it did happen at 8:45, Mr. Sawyer was not checked on again for 4 hours, because it wasn't even Nurse Brown that found him at 2:20 in the morning on the floor. It was the guard. As for Dr. Kotteman saying he'd see him in the first thing in the morning, this was Saturday night. Dr. Kotteman wouldn't have been there until Monday. Now, the cause of the fall, and they did this again, they're talking about the cause of the fall. We're talking about what they did to him after he fell, okay? Whether he had a heart condition, whether he had salmonella, whether he had anemia. The issue is what did they do for him after he fell?
And Ms. Ginson, we need you to wrap up. You've exceeded your time.
Okay. He was being treated for anemia, and he was being treated for Crohn's disease by Dr. Kotterman. But Dr. Kotterman also testified, and that's on page 6 of the reply brief, that it was more likely than not that the fall in the shower resulted in Sawyer's weakness. And he also testified that a bruise to Sawyer's spinal cord could cause the extreme weakness that resulted in the C3, C4 disc injury. Thank you.
Thank you. We thank the parties in this case, and we'll take it under advisement. Our final case of the day is appeal number 23-2948, Dyson Technology Limited versus David Seven Store et al. And today we recognize only Mr. Joseph. Not that you're not sufficient, Mr. Joseph. You're the only person who's going to be here today arguing. Okay.
Good afternoon, and may it please the court. My name is Justin Joseph, and I represent the appellant Dyson Technology Limited. Dyson brought this action to stop trademark infringement on the part of online e-commerce sellers. The defendants in this case failed to respond to Dyson's complaints and ultimately defaulted. Dyson further sought the entry of a default judgment order against the defaulting defendants, which included a request for an award of profits under Section 1117A of the Lanham Act. Now, to support its request for an award of profits, Dyson submitted evidence of the defendants' infringing product sales, which were provided to Dyson directly from the platforms Amazon and eBay, which were the platforms that hosted the defendants' online e-commerce stores. Now, in ruling on Dyson's motion for default judgment, the district court held that all the defendants were liable for willful trademark infringement, as well as false designation of origin. The district court further acknowledged that Dyson had in fact submitted evidence of the defendants' infringing product revenue. However, the district court incorrectly found that Dyson was not entitled to an award of profits, and instead awarded Dyson no damages for the defendants' infringement. Specifically, the district court stated, quote, "The court declines the request to award profits because plaintiff offered evidence of revenue, not profits. Revenue and profits are not the same thing. The court declines the invitation to assume that all of the revenue equals profits." The district court's reasoning here clearly shows that it improperly put on plaintiff the defendant's burden to show its own expenses and other deductions from the total sales and revenue that Dyson had provided. The district court's decision to withhold an award of profits and ultimately award nothing for these defendants, even when Dyson showed evidence of infringing product sales, directly contradicts the language of Section 1117A, as well as this court's decision in WMS Gaming.
And Mr. Joseph, was that argument presented to the district court below?
Your Honor, we asked for profits in our motion for default judgment and in our memorandum in support. The only reasoning that we were given of why we weren't allowed profits was that revenue does not equal profits. Now, this just directly contradicts Section 1117.
No, I understand, but I guess my question is, as you and Mr. Gaudio undoubtedly know, I've seen more than my share of those motions for default judgment. And typically, when they ask for damages, it's pretty perfunctory. I mean, there's an affidavit that's attached and revenues. But I'm wondering whether there was any express argument made to the district court that about this burden shifting that takes place or that's required by the statute.
Yes, Your Honor, that was presented in our memorandum. We didn't have a hearing on the matter. It was presented, and we presented the fact that under Section 1117A, in assessing profits, the plaintiff shall be required to prove defendant sales only. The defendant must prove all elements of costs or deductions claimed. So under Section 1117A, Dyson did its job. It showed the defendant's infringing product revenue. The burden then shifted onto defendant to prove any deductions, which it failed to do so. And the facts of this case are analogous to what occurred in WMS Gaming, Specifically, the plaintiff showed evidence of the defendant's infringing product revenue. The defendant failed to show any deductions, and this court found that the plaintiff was entitled to the revenue, stating, quote, when a trademark plaintiff offers evidence of infringing sales and the infringer fails to carry its statutory burden to offer evidence of deductions, the plaintiff's entitlement to profits under the Lanham Act is equal to the infringer's gross sales. And this makes sense because a plaintiff does not have access to the information or documentation related to a defendant's deductions. And the reasoning of WMS Gaming should have been applied in this case as well.
But of course, you don't dispute the case law that the district court's not required to award restitution. I mean, you got the 1,000 statutory damages, you wanted the profits, but the court was not required to make an award of any type, right?
Your Honor, for 59 defendants in this case, aside from those that were granted statutory damages, we specifically requested for an award of profits. And under Section 1117A, I mean, we proved our burden of showing the defendant's infringing product revenue. And the court, in turn, awarded no damages for those defendants, for the defendant's infringement. And, I mean, sorry, Your Honor.
No.
Okay.
I think perhaps to dovetail on that point, the statute, though, gives, let's assume that the district court acknowledged that, okay, and say, I know that under 1117, the plaintiff only has to show revenue. The defendant's burden to show costs. Defendant hasn't done so. So I'm going to start with a baseline of revenue, but I still have in my discretion under 1117A the ability to vary that amount given in light of the circumstances of the case and my equitable powers. Is that correct?
Your Honor, yes, we don't dispute that. The issue underlying this is that...
Well, the only reason I say that is because, and I'm assuming this is why Judge Jackson and Camille brought it up, is because you talk about entitlement to damages. They're not necessarily entitled to damages a priori. The district court starts with that, and then, depending on the circumstances, may vary from that.
Yes, and that's correct, Your Honor. And yes, we do not dispute that there is discretion provided under Section 1117A. Our issue in this case is that the district court didn't apply any discretion. They just simply didn't follow the law. We provided, under Section 1117A, we met our burden of showing the defendant's infringing product revenue, and we were essentially punished for not satisfying the defendant's burden. So in other words, the defendants were essentially rewarded for failing to participate in these proceedings while we were awarded nothing. And this court in Forsimo stated that the primary function of the trial court under the Lanham Act is to make violations of the act unprofitable to the infringing party. Considering the defendants in this case got to keep all their ill-gotten gains, it's hard to say that this function, this deterrence function, was served under Section 1117A. In sum, this result is in direct contradiction to the plain language of Section 1117A and this court's decision in WMS Gaming. Accordingly, Dyson respectfully requests that the district court's decision be reversed and that this matter be remanded for further proceedings.
Okay, thank you, Mr. Joseph. Case is taken under advisement. And we stand in recess.